From our Orlando office location, which is almost a year old now. We're getting close to that anniversary. I want to introduce one of our superstar attorneys, Alan Schwartzseid, again from our Orlando office location. It's all yours, sir.
All right, thank you, Jeff. Let me get all of this up and running, and then we will be good to get started in earnest. While I do that, my name, like Jeff mentioned, is Alan Schwartzseid. I'm the managing attorney of K. Bender Rembaum's Orlando office, and we're here today to talk about board member certification. What do you actually need to know? What doesn't matter? What does matter? What are you required to do for your owners? So just a bit about the firm. We are 20 attorneys working out of 4 offices, mine in Orlando, our main office in Pompano Beach in Broward County. We have an office in Palm Beach Gardens that Jeff Rembaum operates, and also in Tampa and Miami by appointment. 8 of our attorneys are board certified in this area of law. Community association representation is all we do. Anything that comes up when it comes to representing community associations, recalls, election disputes, things of that nature, that's our bread and butter. It's literally all any of the attorneys at our firm do is representing communities. So we hope you'll think about us if you're not already a client and the need arises for an attorney and you're not 100% satisfied with your current counsel, or because we don't have any monthly minimums or annual fees other than in our specialized collection program. It really doesn't cost you anything to give us a shot. So I hope that this education is something that you all value and that you learn a lot today. And I'd be happy to hear from any of you. My email address is directly here on the first and last slide of the materials. If you ever need to reach out to an attorney regarding a community association issue, please feel welcome to email me. And when I say email me, I do mean directly. I usually respond within 24 hours, whether you're a client or not. I might not have the answer within that time, but almost every attorney, and if not every attorney within our firm, will get you a, hey, gotcha, I'm working on it within 24 hours. So moving on to the actual material, because you're not here for me to sit here and talk about myself or the firm, let's go ahead and get started. So why are we here? Well, Florida law says you have to be, or you have one other option, and I don't think it's a very good one. So you chose the right option. This course is the better, safer way to be certified as a board member in a condominium or cooperative association. And let's be honest, you get to spend a couple hours with me instead of working or doing whatever you would be doing. So there you go. 90 days after you're elected, you do have to either complete a class like this and get the certificate that Jeff just talked about. At the end of this class, you'll get it, presuming you stick around, which you should. And as soon as you get that, you're going to want to get it either to your manager, if you have a property manager for your community, or your community secretary. That's going to go in the official records of the association and prove that you complied with this requirement within the 90 days. If you're not going to take a class like this, and obviously I'm preaching to the choir here, but there are people probably on your board that are not here with you. Those people, if they choose to sign the document that the Florida statutes allow for instead of a class like this, they're basically saying, I've read and will do my best to uphold and enforce our community's governing documents. Here's the problem with that. Documents are most likely not drafted great. Okay, they're conflicting internally. They conflict with the Florida statutes. They conflict with other documents of the association that we'll talk about in a little bit. And honestly, often we can't even discern what the answer to a question is from your governing documents. So if we're doing this every day, all day, why would you think that you can figure out the right answer if we can't? And that's not condescension. It doesn't make sense to not take this class and get the knowledge for free. So anyway, now that I can jump off my soapbox quickly, you're going to give that to your association secretary or your manager. It stays in the official records of the association for at least 5 years, or until the day that you're off the board. Let's say you're on for 10 years and no one else wants to be on the board, so you're not coming up against that cap on how long you can serve on the board. great. Thank you for your service. Just keep that certificate in. You'll never have to take this class again during that time. A lot of people choose to anyway because there's new information added every single time we teach based on things that we learn, statutory changes, which we'll talk about today, etc. Now, you can do this certification for up to 1 year in advance of becoming an elected or appointed director. So people that are not on the board yet can take this class to get a better understanding, but also with the expectation that they will end up on the board. That will still count. They don't have to take it again just because they came on the board after the fact, so to speak. Certification doesn't have to be repeated. I mentioned that. Anyone who doesn't comply with this requirement to either take a class like this and get the certificate and get it into the association's records, or sign the certificate that I mentioned, the other piece of paper that you can sign and get that into the association's records, are automatically suspended from service on the board until that certification gets into the records. So this is not, well, the board needs to have a meeting and decide that that person is off. They are automatically suspended. If you didn't know that they didn't have it, you should be looking out for it. Every board member should be looking to see, or at least asking the person that maintains those records, hey, do we have everything we need in order to comprise a proper board? If the answer to that is no, then you need to get someone, I hate to use the phrase on board, but you need to get whoever doesn't have that certification certified so that there's no question that the things that they're doing are proper, at least according to whether or not they're certified. Failure to have that certification or the educational certificate that you'll get from this class in the association's records doesn't impact the validity of board action. So if that person was technically suspended but still voted at a board meeting, that doesn't mean that their vote doesn't count. It is problematic because hopefully they would be making better decisions after reading the documents and actually understanding what their obligations are, or taking this class and understanding those obligations, but it's not going to impact what the board is able to do. Those votes are still going to be valid. Now, another thing to keep in mind, if service on the board is interrupted and not suspended, meaning you are actually removed from service and then come back, you still need to retake the class. If you're suspended, once the suspension is up, you don't need to retake it. So just note the difference between an interruption in service, meaning you're actually fully off the board, versus just being suspended. Okay, think of when you were in school being expelled versus being suspended. The interruption is the expulsion example. Okay, moving on. Condos, how do they even come about? Well, the law says they exist, so they exist. It's kind of like money being printed. It doesn't have any inherent value unless you give it value. A condo doesn't exist, even though there are 4 walls that might be closing it in and a ceiling and a floor. It doesn't exist as a separate piece of real property, except for the fact that there's a declaration of condominium. And more importantly, there's a statute, Chapter 718 of the Florida statutes, which created condominiums in Florida. Okay, keep in mind, that's not the only chapter. We'll refer back to Chapter 718 pretty regularly. You probably will as a director as well. But there's another chapter that a lot of people don't seem to know about. And by the way, if you're in a co-op, because I can't see a show of hands, I will refer back to co-ops. Most of the information is going to be identical here between condos and co-ops. They're under Chapter 719 instead of 718. So just keep in mind, if you're in a co-op, whenever I say 718, you're going to look at the comparable statute in 719. So the other statute that a lot of community association directors, managers, and even attorneys somehow don't know is also applicable to a condo or a co-op is Chapter 617. That's the not-for-profit statute. Because keep in mind that every condo in Florida, or almost every condo in Florida, is a not-for-profit corporation. Okay, it exists and is governed by a corporation. That board of directors that you sit on, or maybe you're a manager or an owner, but the board of directors that most people on this call sit on is actually the board of directors of a corporation. Okay, so you're not just governing a community, you are running a business. Whether it's a for-profit business or not, doesn't make a difference. So just keep that in mind when you're making decisions on behalf of that community, that condo, the co-op. It needs to be a business decision, not an emotional one. Making business decisions based on all the information available is what protects you as a director from being sued personally. We'll get into that later. And you're mostly going to be covered if you're sued by an insurance policy or an indemnification provision. But keep in mind, it is possible as an individual director to be sued in that capacity. Okay, you've got your declaration of condominium. That's going to create title for your units and for your common elements. It's also going to contain covenants and restrictions. It's basically, hey, these are the things you can and can't do in a unit or on common elements. Okay, that's your covenants and restrictions. All owners in a condo own an undivided interest in the common elements. These are things that, your I can't think of the word right now, but that would be helpful. Your parking lot, your pool, all of these types of things are common elements. You actually, as a condo unit owner, own a partial share of that. Okay. In a co-op, same deal. You own a partial share. There's a little bit of a difference in ownership because in a co-op, normally you own a share of the corporation rather than owning real property within the community. But that's the biggest distinction in my experience between a co-op and a condo. But in either one, you technically own a share of the common elements. Okay, material alterations, when you're changing the way that those common elements look, changing the appearance. Typically, the condo board can't just unilaterally decide to do that. You need a 75% approval of the unit owners unless the declaration provides a lower percentage figure. Okay, powers and duties. What can an association actually do? And more importantly, for your purposes, what can the board do and not do? Okay, so all of these things, I'm not going to go through them in detail, but these are all powers and duties that the association can exercise in maintaining and operating a community, whether it's a condo or a co-op. Okay, and I'm going to skip the co-op, not because I don't care, but just because there's a lot of material to get through. And every time I mention it takes off a second or two. So, you've got a general grant of power, regardless of what's in the declaration or any other governing documents, to do all of these things. You can sue and be sued, purchase property. I'm not going to go through them in depth, like I said, but there are a lot of things the association can do. And this is just a small list of the empowerments that are statutory and automatic for your condo board. Now, some of these things might require a member vote. For example, purchasing real property, it says 75% vote if the documents are silent, and don't say, hey, the association has the ability to buy land and the board gets to decide. But a lot of these things are simply done by either the members or the board. And we'll get into what some of those are later on. Okay, which year's statutes apply? Keep in mind that under Florida law, when you sign a contract, the statutes in effect when that contract was signed are pretty much shoved right into the terms of that contract as a matter of law. So if a statute changes after the fact, the U.S. and state of Florida constitutions protect you from changing what your agreement was, because you might not have entered that agreement. You might not have bought into a condo if you had known that that law might change and change the way that you're allowed to use the condo, change voting requirements and things of that nature. Okay. Now, there's an analysis that attorneys are going to do when you're deciding which year's statutes apply. I'm not going to go in depth, but I will go in a little bit of an explanation. Okay. If your declaration provides that the Condominium Act, and this is this purple language, this is what we call magic language, Kaufman language. If your declaration says that the Condominium Act, as amended from time to time, is incorporated into your declaration, and that is what you will operate under as a corporation, as a condominium, as a co-op, whatever, then every legislative change automatically applies, because everyone in the community agreed by virtue of that declaration and that specific language that all of the statutory changes would apply to your community. If that language isn't there, you have to do an analysis. And when I say you, I really mean your attorney. So let me be clear. The board should not be doing an analysis of which statutes apply. I'm just going to say that up front. Frankly, neither should your manager. That's a legal decision that you should be getting counsel for. But if the changes, well, let's move on to the next slide, because that's what's going to address what I was going to say. Procedural laws, meaning you're changing the means and methods for the application and enforcement of existing duties and rights. We're not changing substantive rights, okay, not vested rights. We're not changing the way that we interact or the way that we've agreed to interact. We're changing the procedure for elections, not changing whether you have the right to vote at that election. Okay. These procedural changes are all going to apply regardless of whether that Kaufman language is there or not. Substantive changes generally will not apply if you don't have that Kaufman language in your declaration saying the statutes are applied as amended from time to time, because that is a constitutional impairment of an existing right that you have, or that the owners in general or the tenants in general have in that community, that can't just be arbitrarily changed because the legislature of Florida thinks that something different should be done. So generally speaking, these are some examples of what might be considered a substantive vested right. If these rights are changed, chances are, if you don't have that Kaufman language, that change won't apply to your community, and the older version of the statute will be what applies. And again, when I say older, I really mean the statute that was in effect as of the date your declaration of condominium was recorded. Hey, when I mentioned earlier, these governing documents, they conflict with each other, with the Florida statutes, and they also conflict. But when there's a conflict between these documents, you got to ask yourself, well, what do we do? Which one do we follow? Well, just remember the old expression, a little dab will do you. And what I mean by that is the order of importance for your governing documents are always going to be your declaration, then your articles of incorporation, then your bylaws. So declaration of condominium, articles of incorporation, and then bylaws. Let's get into what each one of these does. And before we do that, let me clarify that if you see this conflict exists, let your attorney analyze whether it is a true conflict or if it's just different provisions for different circumstances that may or may not apply to the situation you're looking at in particular. But if it is a true conflict, that's when you amend your governing documents to remove the conflict. Okay. And again, your attorney should be helping with those amendments. So let's get into what each of these documents is. The declaration, which people refer to as the CC&Rs, usually that's more in an HOA, but I've heard it in a condo anyway. That's your association's constitution. It is the most important document. It's the contract that binds the members. It runs with the land. It's basically everything in that declaration is going to be presumed valid unless it's arbitrarily enforced or there's case law saying you can't have that. For example, laws were recently passed that basically say if you have a rule that says no Jews can live in our community, well, chances are that's not going to be enforceable. And we'll get into why later on if you're not really already aware of why that's problematic. But this is the document that everyone kind of bought into. Everyone knows if they buy into a condo, there is a declaration or some document out there that they should be looking at. It's recorded in the county public records, which means everyone, including people that live in Zimbabwe at this point, are deemed to be on notice. And the reason for that, and when I say on notice, I mean they are deemed to be on notice of everything that's in those recorded documents. The reason for that is that it's accessible to literally anyone with an internet connection or anyone that can go down to the county records or have someone else go down to the county records and get them a copy. It's public record. So anything that's in the public record is deemed something that everyone has knowledge of. Okay, it's called constructive notice. That's the legal term. And the reason that this is presumed valid, unless it's arbitrarily enforced, is because the members get to vote on pretty much any changes to this declaration. Okay, the articles of incorporation, it's basically going to state the name and purpose of the corporation. Sometimes that'll include some of the officers' duties, the director information, who can and can't be a member, who can and can't serve on the board of directors, etc. And then you've got your bylaws. Most people think this is what controls the day-to-day operation of the community. Really, that's your declaration that's going to have your covenants and restrictions. The bylaws are generally going to say how are meetings run, what are the directors and officers' responsibilities, and things of that nature. And then finally, you've got your rules and regulations. That's generally going to be board-made rules without member approval, which means they're scrutinized even more closely by courts than any of these other documents. So again, just like we go in order of level of importance, it's the same order for level of scrutiny by a court to see, well, is this really a reasonable restriction, etc. Okay, moving along to transfer fees. This is what happens when someone sells or refinances a unit. If a condo technically cannot charge a fee in connection with the sale, mortgage, lease, sublease, or any other transfer of a unit, unless the association is required to approve the transfer and the fees provided for in the governing documents. In other words, you can't charge this $150 fee per applicant, and there are some exceptions to that, but you can't charge the fee unless it's provided for in the governing documents, and the authority to basically screen tenants or owners is also provided for in the governing documents. So absent one of those two, or preferably both of those two items, that you have the approval to screen people and you have the approval to have this fee charged, you're not going to be able to charge it under Florida law. If it's a continuation of a previous lease, keep in mind no new charges are allowed. You can't suddenly decide every year we're going to screen this tenant again and get my $150 every year. I don't necessarily agree or disagree with that. There is the possibility that additional criminal history comes up, but you're limited in how you can use that criminal history anyway. Their finances might change, which might impact you, but realistically, their primary responsibility is going to be to the landlord, who is the unit owner. So a lot of that information probably doesn't matter to you either, etc. If it's authorized in the governing documents, you can also require that a prospective tenant place a security deposit in an amount not to exceed 1 month's rent into an account that's held by the association. It's basically to protect against damages by the tenant or whoever else. This is basically a landlord-tenant issue, is the way that it's addressed by the law. One other practical tip that I've seen go poorly, and so to avoid the problem that I've had clients face in the past, make sure that it's clear when these people are making this deposit, who the money goes back to after the end of the lease, or when the money is being sent back. The declaration should be clear. If it's not, I suggest amending, because the alternative is, let's say this is a $2,000 deposit. Okay, that's a decent amount of rent for a lot of places in Central Florida, probably higher in South Florida or like Orlando and some more populous metropolitan areas. Okay, great. Regardless of what that number is, it's probably not going to be enough to cover your attorney's fees and costs in the interpleader lawsuit that might have to be filed if you're not sure who this money goes to. That interpleader is basically a lawsuit that says, Judge, we've got two parties here. It's going to be your unit owner and their tenant or their former tenant, saying they're both entitled to these funds. I don't know who to send it to because my governing documents aren't clear, or the form that they have to complete in order to make that deposit and be approved is not clear enough. We don't know who it goes to. So we're going to put the money in the court's registry, and we're going to hope that there's enough in there for us to take our fees out so that the association doesn't end up coming out of pocket just to figure out who to send that money back to. So usually when that interpleader is filed, it's a roughly $5,000 to $7,000 process to file the lawsuit, get the funds into the court registry, get a court order awarding the association's attorney's fees and costs, pull the money out, and be dismissed from the case. So bottom line, I'd rather spend the $5,000 or whatever it is on a one-time amendment, and chances are this type of amendment to the governing documents would not cost $5,000, but I'd rather see an association spend that money on the amendment and never have to worry about this issue again than have to worry about every single deposit becoming this type of lawsuit. So just a practical tip. Let's see, moving on. Estoppel certificates are a big deal. Once you get a request for one of these estoppel certificates, you have 10 business days to provide the estoppel certificate. And we'll get into what it actually is in just a minute, but I want to be clear. You have 10 business days after receiving the written or electronic request for the certificate from one of these people in the first bullet point here, or if you don't produce that estoppel certificate within those 10 business days, you don't get to charge any fees for preparation. Okay, that's not good. You want those fees. Okay, and we'll get into what those fees are as well. So make sure that anytime you get an estoppel certificate, you actually tell your attorney if the account's in collection and let them complete the financial portion. and get it back to you so you can submit the full estoppel certificate as one document with the payoff letter that they might prepare or whatever other documentation they're going to get to you. If it's in collection, do not state what is owed, because any attorney's fees and costs, any other amounts, any violations of the covenants that are not listed on this estoppel certificate are most likely going to be waived and unrecoverable if someone closes on a transaction, whether that's a mortgage, a sale, whatever it may be, in reliance on that estoppel certificate. This is a document that is literally based on the theory, which is a legal theory, of estoppel, which is I should be able to rely on what you tell me. So if you tell me that this is all that's owed, I can rely on that and go ahead and close my transaction. And you can't come back after the fact and say, oh, we missed XYZ. I'm sorry. You now have to pay an extra 10 grand. Well, I don't own that property anymore. And the new owner sure doesn't want to pay it. And they don't really have an obligation to pay it. Okay, so make sure that everything that we list in this next slide is actually included. This is a document that basically says, here's what's owed. Here's what you need to do in order for this new owner to come in free and clear of any problems you might have had with me as the seller of this property. Now, it could be for a mortgage, it could be for a refinance or some other reason. I'm not saying that it's only in a sale, but you will most likely see it in sales and refinances. The certificate needs to be provided by hand delivery, regular mail, or email when it's issued, on the date that it's issued. It needs to be signed by an officer or authorized agent of the association, who is also the person that is issuing the estoppel certificate. Let's see. Yeah, you want to handle these as soon as possible. Okay. So this is some of the information that's going to be included in the estoppel certificate. We're not going to go through it in detail, but again, it's basically, here's how we're issuing this. Here's information relevant to this particular property. Here are any problems we have with the property, which we'll get into the assessments right now. And it's also going to list any assessments that are coming due within the 30 days that it's good for, or 35 if you're sending it by mail. I rarely, if ever, see it sent by mail. It's almost always email or fax. Let's see, is there a capital contribution or other resale or transfer fee? Is there any open violation? Again, do the rules require approval of the transfer or any tenants that are coming into the property, etc.? Is there a right of first refusal, meaning the association gets to say, we don't want this person to buy, but we'd be okay with this other person buying into our community? And then there's a bunch of other information that goes into it. You should have a form usually being provided by the person that's requesting it. If not, your attorney can prepare a form. They probably have one already ready to go that just needs your community's specific information shoved into it, frankly. And I have one that I just send over to my clients and tell them, you can go ahead and fill it out. And I charge a nominal fee to get that to them, because there is some value in not having to go through the entire statute like I did and put all of the information together. It's just a matter of gathering that information for your particular community. Now, there are fees that can be charged. A reasonable fee not exceeding, and it's currently, as of last year, $2.99, can be charged if no delinquent amounts are owed to the association as of the date that this certificate's issued. Okay. If there is a delinquency, meaning that there's something owed to the association that hasn't been paid, but it is past due, and another $179 fee can be charged. Okay. This is usually going to be where your attorney steps in, and that's basically what you get to charge for them. Okay. I have seen management companies charging estoppel fees of $179 and then just tacking the attorney's fees onto the association's account. I won't comment on which one's the right way to do it right now, but those are two different ways I've seen it done. If it's requested on an expedited basis, meaning it's being provided within 3 business days after receiving the request, there's another $119 that can be charged. That was increased effective last year as well, as was the $179. Oops, sorry about that. And in order to charge an estoppel fee, you need a board resolution. Now, that's fairly simple. We haven't talked about those yet, but it's literally a document that the board has a meeting and signs that says we are now allowing basically list all of these fees. And that's another thing that your attorney can prepare, or frankly, you can take these slides, put them in a resolution form and sign. And that would be good enough, in my opinion. You just have to have the motion and what is being approved in that resolution, what's being resolved. And then if it's delivered late, like I mentioned earlier, you can't charge for preparation. There are also, for bulk purchasers, bulk sellers, whatever you want to call it, fees that are listed on this slide in the bullet points. Those were also increased last year. And so these are the only charges you can have. For example, if you're providing for 25 or fewer parcels, meaning even if it's 2, you can only charge $896 in the aggregate. It would normally, where you say in the aggregate, it would probably mean that it's going to be less than this for 2. It would be this $896 if it's 3, because the $299 times 3 would be just over this figure. I think it's $897. My math is bad, so just ignore me for when it comes to math. Just expect that it's going to be automated if I'm doing it. So I'm not going to go through each one of these, but just keep in mind, if you're talking about multiple parcels that are the same owner that is selling or refinancing and asking for all of those estoppel certificates simultaneously, these are the fees you can charge instead of the $299. All of the other fees you can still tack on top of this, but keep in mind, and if you've got a resolution and if they're applicable, you can tack them on. But these are the ones for if you have multiples being requested. If the sale or the refinance does not go through and the transaction is not completed and the person that requested the estoppel and paid for it requests a refund of what they paid within 30 days after the closing date that was planned, that person is entitled to that refund. So the association should keep those funds available during that 30-day time frame after the transaction was supposed to close, just in case that person requests it. The dollars being sent back in exchange for that, keep in mind that just gets tacked on to the owner's account. So it becomes basically an assessment or a cost, depending how you look at it, and it goes on to the owner's account. In the same manner as an assessment, to me, means as an assessment. I know some attorneys will say, no, that's a cost because it was a cost incurred by the association paying whoever prepared the estoppel certificate. So the right to reimbursement can't be waived or modified by any contract, meaning the association can't say, well, I don't care what the statute says, you're not getting your money back, we did the work. Okay, well, you did the work, you're entitled to your money, it's just from the owner instead of the money that you had in hand. And then the prevailing party in any action brought to enforce a right of reimbursement, as well as regarding any estoppel not being issued or being allegedly incorrect, you're entitled to your actual damages and attorney's fees and costs. And I apologize, I've got an eyelash here in my eye, so I'm going to block my eye and fix that problem. Okay, that's a first for me. I've done a lot of these webinars, but cleaning out my eye, I have not done during a webinar before. And again, these amounts just changed in 2022, the fees that you can charge. It's upped every 5 years, or at least we hope it's upped instead of decreasing every 5 years. And so we don't expect that to happen for another 4 years at this point. So just expect that what you're able to charge now, what I mentioned earlier, is all you'll be able to charge for those next 5 years, or the next 4 at least. The estoppel is good for 30 days if it's hand delivered or emailed or faxed. That's not mentioned here. And it's good for 35 if it's mailed. Again, I don't know of anyone that mails these out, but if that's what you're doing, it's good for 35. If you find out that it was incorrect or new information becomes available and you find that you need to amend it, you do have the obligation to update that at any time if you find that it's inaccurate, which is why we include the assessments that are coming due during those 30 or 35 days in the certificate itself. If you find that a change is needed, you need to make that amendment and send a new estoppel certificate. I usually will label it as an amended estoppel certificate. That is then good for 30 or 35 days in and of itself. You don't get to charge another fee because you're technically just correcting what you already sent that was wrong. If it's new information, still unfortunately in that event, in our opinion, you can't charge a second fee. Now, again, this bolded language is what's important. I mentioned it earlier. Anything that's not in this estoppel, you're not collecting. Let it go. So bottom line, don't mess up, because I've seen communities lose out on $5,000 or more by not asking their attorney what was owed for, let's say, an enforcement matter that the association had the right to collect all of the fees for. So just keep all that in mind. There is other information that can be requested. You can charge $150 plus the reasonable cost of copies and attorney's fees incurred by the association responding to those requests from the prospective purchasers, lien holders, etc. There is special language to avoid liability in the Condo Act if that information isn't accurate. This is really information that's mostly being requested by lenders such as Fannie Mae, Freddie Mac, others, etc. So we're going to move on to other purchase and sale documents. You got your condo question and answer sheet, needs to be updated annually and be provided to prospective purchasers by the association. And then not relevant to the association, but relevant to any seller, there is a duty to provide the buyer notice of all hidden defects. That could include things that are technically in common elements, including the walls and things like that, if you know of it or have reason to know of it. We're not going to get into general real estate law here, and that's frankly not what I do, but we will get into one of the changes to the statute this year. When it comes to construction and other defects in a community, especially in condos, this is relevant. The statute of limitations related to condo construction defects will change effective July 1st as of this recording. That's next week. And if you have one of those types of claims pending, you might want to chat with your attorney about whether you might have to file a lawsuit sooner than you might have anticipated because that statute is changing. This is kind of what we saw within the last few months with respect to negligence lawsuits. And, you know, I'm not going to get into detail about any of these statutory changes. I will mention a couple of them, but my recommendation, rather than us taking a significant amount of time here today, which it's already 12:40 and we only have a little bit of time to get through another 160 slides, which we'll skip some of, but bottom line, I would highly recommend reading the most recent, actually the previous edition of Jeff Rembaum, my partner's Rembaum's Association Roundup. You might recognize his name from the name of the firm. He does put that out very regularly, and the legislative update was not the most recent one, but the one before that. It will include everything relevant to condos, HOAs, co-ops that changed in the statutes this year. It's about 25 pages. It's actually a pretty easy read. If you know Jeff, you know he likes to write in a way that everyone can understand. Not necessarily an actual fifth grader, but you know, it's one of those, he writes to people, not other lawyers, and that can be very helpful. Jeff, did you have something you wanted to add?
Yeah, you could also have a quick sip of the water break here. The link we just placed into the chat is the link for the document article that Alan just mentioned. And save that link, because what we did is that link will never change, but the content on that page will always contain the most recent version of what Jeffrey Rembaum writes for that article. So like when Alan just mentioned, there's a version 1 and a version 2. With that link, it won't matter. This page, again, in the chat, will always contain the latest and greatest. Back to you, sir.
All right, thank you. So let's see. I think we addressed everything in this slide, so we can move on now. All right, every prospective purchaser who entered into a contract for the purchase of a unit is entitled, at the seller's expense, not the association's, to a current copy of all the governing documents of the association, the financial information required by Florida statutes, section 718-111, the FAQ sheet that I just mentioned, and the prospective purchaser is also entitled to receive from the seller, again, not from the association, a copy of a governance form, which is provided by the division, which is not the association, summarizing governance of condo associations. Okay, so these are all things that the seller needs to provide. Now, when it comes to that governance form, again, it's information that the division basically considers helpful to a purchaser in understanding how a condo association works. That's one of the things that I think the division did that was a very smart idea, because there are so many people who ask, frankly, uninformed questions is the way that I would put it. And that's putting it very kindly. And make uninformed complaints regarding condominiums. This is basically a baby version of what you're here learning today. Okay. I think that could be more helpful, but it's extremely helpful for people that want to better understand how a condominium operates. Okay, that's just continuation. Suspending voting and use rights. These are really helpful tools for covenant enforcement and for non-payment of assessments and other monetary obligations. Okay, you can fine or suspend use rights of an owner or of their occupants and everyone else related to the unit after following this procedure, even if nothing stated in the governing documents. So you automatically have this right under the statutes. The board votes to levy the fine or the suspension. Pretty simple. You hold a board meeting. The board says, do we want to levy this fine or this suspension? The vote is yes. Okay, great. Move on. Next step. If the answer is no, you're done. Nothing more to do. No suspension, no fine. The next step is you give a 14-day notice of a hearing before a separate impartial committee that is not related to any of the directors, officers, managers, etc. There is question among experts, is what I'll say, as to whether or not you need to hold that meeting or just offer one. Some people will say, well, if they don't show up, you don't have to hold the meeting. My response is, would you say that about a board meeting? Because if the answer is no, you probably need to hold that meeting and say, okay, they didn't show up. We vote. It's a quick meeting, done. But I still think you need to at least have the meeting, even if it's very quick. Because otherwise you could easily say, well, we don't have a fining committee that can make this decision. But since we didn't have to hold the meeting, it doesn't matter. That's not the way the law works, in my opinion. So again, at this meeting after 14 days notice, if the fining committee doesn't approve the fine or the suspension, the board doesn't get to levy it. This is a final decision. Now the board can try again later, but they cannot go ahead and just levy the fine or suspend use rights, despite the fact that this committee said no. And then if it is levied, or if the fine is levied, the suspension goes into effect. You give notice to the owner. A fine is due 5 days after it is actually approved at the committee meeting. The maximum for a fine is $100 per violation per day of a continuing violation, up to $1,000 per violation. Condominiums cannot lien for unpaid fines, period. So don't think that this is something that you're going to use and then all of a sudden have a lien. Now, I don't really like fines unless they're used the right way. And when I say the right way, what I mean is, if you're going to take the time to tell someone, because you did something wrong, this is the penalty. I tell my kids I'm going to do something. I tell them what the penalty is. I say, okay, you can't use your iPad anymore. And then I see them using their iPad, but I don't say anything. That's what most communities do when it comes to fines. Okay, they levy the fine. They tell the person that you owe the fine, and then they do nothing until an estoppel certificate is requested, or the owner comes to them and tries to settle something else maybe. Okay, if you're not going to take this as far as it needs to go, file a small claims lawsuit to enforce the fines, get your judgment and collect on it, don't bother fining. Use suspensions instead. Use some other enforcement mechanism, preferably the customary self-help if you've got the opportunity to do that, which is basically your governing documents say you can enter onto a lot or into a unit and go ahead and cure the violation yourself and charge the cost to the owner. Do that. Or if not, send your standard internal notices and then turn the violation over to council to get an injunction and force the people to do what they were supposed to do all along. But fining people without being willing to enforce the fines, all it does is kill the board's credibility, and it can bleed over into other issues where people don't believe that the board is actually going to go forward with the remedies, the enforcement mechanisms that are available, because you're sitting here and saying, well, you got a fine. Okay, so what? It doesn't matter until you do something about it. Okay, so I'll again jump off my soapbox, but I do like to mention, if you're going to fine people, move forward and do it, take it to the end. Now, the suspensions that we talk about, keep in mind there are certain things that you can't suspend. You can suspend use of the gym, the pool, the laundry room, the clubhouse and rec room, but you can't suspend use of limited common elements that are used only by that particular unit. For example, the balcony or parking spot. You can't suspend common elements that need to be used to access the unit. In other words, the hallways, the elevator, things of that nature. Utility services, in other words, electric and water, potentially internet. I'm not aware of any ruling on that yet, but I anticipate that if it hasn't occurred yet, it will soon, as to whether internet is a utility. And then parking spaces are the other thing that you can't say you're not allowed to use that anymore because you are in violation of our covenants. Keep in mind all these suspensions. Sorry, if it's a monetary obligation, which we'll move on to in a minute, it needs to be over 90 days and over $1,000 in order for you to use that as the basis for a suspension in a condo. I think that was effective either last year or the year before. You can also suspend the right to vote, which we'll get into in a minute. And then suspension for failure to comply can't be imposed unless the owner and the occupants had an opportunity to appear before that committee, just like the fining committee, and were given the opportunity to speak. So again, basically, I think that you need to have that meeting. You need to embody that committee, have the committee hold the meeting, and then report back to the owner, hey, sorry, but we levied the fine, we suspended your use rights. Then you move forward. Okay, again, 3 members of that committee, not officers, directors, or employees of the association, or their spouses, parents, children, brothers, or sisters. Okay, fine, we talked about this. Fine cannot become a lien. It's due 5 days after the date of the committee meeting. We talked about all of this, so that's good. Okay, suspensions for failing to pay. The board can just unilaterally decide if it's for failure to pay, you don't need to have the separate meeting. Okay. You just basically, the board meets and decides we're going to suspend this person's use rights because they're 90 days delinquent in a monetary obligation, and that monetary obligation is more than $1,000. Okay, an association can suspend those rights. In order for that suspension to take effect, the board needs to give notice, not just hold the meeting, but you don't have to have that second meeting and you don't have to impanel that second committee. It's effective until the monetary obligation is paid in full, meaning if there's still a penny left, that monetary obligation is not paid in full and the owner is still suspended unless the board decides otherwise. Motion can be done one time if it's done properly at a board notice, properly noticed board meeting, but you might not want to do it that way, meaning you can do it as well, we're only suspending these 15 units. Okay, the problem is you can get yourself in trouble when it comes to, depending on the way that you do the suspension and describe the units, you can get yourself in trouble with respect to fair debt laws and other things. So my suggestion is generally refer to them by unit, not by name, and don't give specific dollar figures. Just say this unit is delinquent in payment for at least 90 days. Don't give any specifics at all. The board should have the information available in advance of the meeting and be able to vote. Another avenue that's not mentioned in the slides, you can send a rent demand notice to any tenant if you've got a past due assessment or other monetary obligation. And basically the statute says if the tenant pays the association pursuant to that kind of notice, which is a form notice that the statute provides, if the tenant pays the association instead of their landlord, that is not a breach of the lease and they can't be evicted for that. So that's the way that tenants are protected. They only have to pay what they would have paid their landlord. So if they're living there for free, even if that's in violation of the association's covenants, they probably don't have an obligation to pay you anything. So the way that we usually do this is every time there's a new tenant in, send it. Doesn't really work for short-term rentals because if they've already paid the rent, which is automatic when it comes to those short-term rentals, they don't have to pay you as well as paying their landlord. It's the next installment of rent that they have to pay the association. Okay. Generally works best where rentals are in high demand. So we see this a lot in Kissimmee really being successful, near the theme parks, Miami, places like that, where you're going to get another tenant in there right away. You can technically evict a tenant who refuses to pay the association's assessments. The question then becomes, do you want to tack on another $2-3 grand in attorney's fees on top of what the person already owed you, the unit owner already owed you? The answer is usually no, but it is an option. Voting suspensions, once it's suspended, the whole lot or the whole unit doesn't get to vote at all, doesn't count towards any votes being counted. So if you had 100 units in your condo and you suspend 3 units voting rights under these provisions, you're talking about now having 97 potential votes. So it can actually make it harder to have an election, have other things. It also doesn't apply to limited common elements, ingress and egress, meaning getting in and out. Question then becomes, well, then does this suspension apply to the gate? Because they can still get in. It's a method of getting in and out. My opinion's always been that it's just one method. It's not saying you're not allowed into your community. It's making them show ID maybe instead of using a key fob. Shutting off those fobs, by the way, tends to work really well when the boyfriend, girlfriend, or spouse finds out the other one didn't make the payment. Bottom line, that payment's going to be made real quick once the spouse has to sit there and go show ID, even though they personally did nothing wrong. And then utility services, again, can't be shut off either with this. We use it pretty regularly. The suspension doesn't apply to certain things like I just mentioned, but it will apply to most of the items that you can use when you're suspending use rights. When it comes to voting, those rights, as I mentioned, can be suspended as well. Delinquency needs to be greater than $1,000. And you know what? I think I said that suspending use rights also needs to be greater than $1,000. I believe I might have misspoken there. I think it's only voting. So I apologize if I misspoke on that one. I was thinking of the $1,000 because it wasn't in my slides, and I just added this today to make sure I was giving you accurate information and failed. So here we are. So through board action, if you're more than 90 days delinquent in any monetary obligation due to the association that's more than $1,000, and proof of the obligation is provided to the owner 30 days before the suspension is going to take effect, the association can say you no longer have the right to vote. However, we say recent case law, it was really in 2020. The De Soleil case basically says that for declarations that were recorded before the effective date of the amendment, the authority to suspend voting rights needs to be in the association's declaration, or the declaration needs to contain that Kaufman language we discussed earlier. And the reason for this is voting is a substantive right. Okay, so it kind of makes sense that you might not be able to use this new statutory mechanism if your declaration wouldn't allow for substantive changes to apply retroactively. I know that that's a very legal explanation, but it does make sense to people that are in this arena, so to speak. So I'll skip some of the examples because we're running short on time already. Let's see, voting suspensions, be careful what you wish for. It does impact if someone's rights to vote is suspended. It impacts the number necessary to establish a quorum, like I mentioned, and it requires a higher percentage in reality of the people that are voting. So let's move on. Member meetings. Okay, the annual meeting is going to be held at the location provided in the bylaws. If they don't say where it's going to be held, it needs to be held within 45 miles of the condo property. You call that meeting based on whatever the bylaws say, and they will say it. I don't know of any bylaws that don't say how to provide notice of an annual meeting or how to call it. Elections will occur at or in conjunction with the annual meeting. So it's basically going to be at the same time, not 3 days later. The bylaws are going to say most of the information you need. If you're talking about a special member meeting, those are basically all meetings other than the annual meeting where the members are voting on something. It's called by the board or upon written request of at least 10% of the unit owners, unless a different percentage is provided in the governing documents. So that's called for a specific purpose. It may be an amendment to the governing documents, a recall, waiving or partially funding of reserves, which we'll get into later, etc. The members are entitled to at least 14 days notice of all member meetings via mail, hand delivery, or if they've approved electronic delivery of notices, that method. And there needs to be an affidavit by the person that provides the notice saved in the association's official records. Frankly, it may not be required by statute or by your declaration, but my suggestion is have an affidavit by whoever's providing notice of literally anything to the members, have an affidavit signed and put in the association's official records. because later on, that person's not going to remember, and refreshing a recollection of what you sent out and when might not be the easiest thing, even though it's definitely possible. So if you've got that affidavit every time there's a mass mailing to the community, and you say exactly, here's how notice was provided to this group, here's how electronic notice was provided to this group, etc. Meeting notice was posted as well. You're basically backing up so that you've got evidence that your attorney can then use to say, hey, this was created at or around the time that all of this occurred. It's now a business record of the association, and it's also evidence because it's in the form of an affidavit. Even the annual meeting notice does need to include an agenda. Basically, you have to let everyone know what is going to be discussed at this meeting so that they know whether they should show up or not. Special meeting notices must specify what's going to be discussed, and other issues such as special assessments may require special notices as well. For example, a special assessment notice, if you're discussing those at the meeting, it needs to specify what the special assessment is for. In other words, what are we trying to pay for using these funds, as well as the fact, what is the dollar figure that is the total, and what is everyone expected to pay if the special assessment passes. All right. Oh, the notice for any meeting needs to state the date, time, location, and preferably an agenda. Let's see. Electronic notice is only allowed for pretty much everything if the members unilaterally and individually consent to receiving notice that way. It can't be used for recalls or votes about retrofitting condos with fire sprinkler systems. An owner who designates an email address is responsible for ensuring they receive those emails. The association needs to just make sure that it was properly sent. So if that bounces back, not the association's issue. Let's see. Membership meetings may need to be held at a physical location, even though lots of them are held via Zoom. You need to provide a physical location for anyone who doesn't have the capacity to attend in that manner and tells you they won't be able to attend in that manner. So it's basically an accommodation for their specific needs. Okay, quorums, decisions, and participation. A quorum is a majority unless the governing documents say otherwise. Member decisions are generally going to require a majority of votes during a meeting at which a quorum is present, unless your bylaws say otherwise, or unless you're making amendments or things of that nature that require other specific percentage votes. The members can attend and speak at meetings on all agenda items or anything that's open for discussion, whether that's a member meeting or a board meeting. The association can and should adopt a policy restricting the frequency, duration, or time, which is at least up to 3 minutes, for each member's statements. In other words, the members have the right to speak at meetings, okay? But you can govern how long they speak, what time frame they speak in, whether it's before or after the board's discussion, before and after the board's vote. My personal opinion, which you can take or leave, is that having that after the board votes means that whole information that the members are providing, all of that information is meaningless for purposes of that meeting, because you've already made this decision regardless of what they say. That said, there's nothing that says you can't do it in that order. You can also require that members, and this is all only if it's in your procedures, in writing and adopted by the board, but you can also require that all members say in advance, I want to speak at this meeting, and sign up on a sign-up sheet at the beginning of the meeting. And if they don't, they might not be allowed to speak at all. I also hear a lot of associations saying, oh, we don't have any problems right now, so we don't need those types of policies and procedures in place. Well, wait until you do, and it's too late to actually get them in place, because Mr. John Smith over there is screaming at everyone throughout the course of all meetings of the board, where that's where you would be trying to get these things put in place, these policies and procedures. Okay, wait until then, and just understand you will not be able to put those procedures in place because you won't be able to have a board vote. And also you won't be able to put them in place because you can't hold a regular meeting, and you're going to have problems at all of these meetings. You're going to end up spending money, having police presences, etc. And I'm not saying this will happen with every community, but it tends to eventually happen. There's always one in every community that causes these types of problems and requires a lot more than you thought should be necessary. The members can record all meetings, video or audio. They don't need to provide notice in advance. It's a public meeting, at least public to the extent of the membership of your community. You can have closed meetings with counsel to discuss potential or ongoing litigation. In other words, attorney-client privilege meetings where the members are not allowed to attend. And you can also close off to the members any meetings to discuss employee matters, salaries, etc. Keep in mind, those records that result from the meeting minutes, any of those salaries that go into the other official records of the association, those are still open to the members' inspection. It's just the meeting itself that gets closed. You can vote by proxy. General proxies are basically, hey, you can vote however you want, just do it on my behalf, do what you got to do at a specific member meeting. Okay, it's not just for the rest of time, you can vote on my behalf. That's a power of attorney. It's a completely different kind of concept. And whether or not it's allowed is another issue. Okay, a limited proxy is basically you can vote in this way for this particular issue or these particular issues because I'm not able to attend the meeting that this vote is being taken at. Okay, in condos, you can use a limited proxy for certain purposes. Basically, anything the Condo Act requires or permits a vote of the unit owners. I use the catch-all because the rest of it doesn't matter in the face of that term. Okay, both general and limited proxies can be used to establish a quorum. No proxies can be used for condominium elections. That's why you have ballots instead, and we'll get into elections next. But they can be used for other business that's done at the same meeting. Any proxy is effective only for that meeting and any adjournments up to 90 days. So in other words, if you couldn't get enough people to show up in person or by proxy to actually hold a meeting because you had no quorum, then you can reschedule the meeting within those 90 days and all the proxies that were already signed are still going to be valid during that 90-day time frame. Every proxy is revocable at any time at the pleasure of the member executing it, meaning I didn't think I'd be in town. I got home early. I can show up at the meeting now. I can show up at the meeting and say, nope, that person's not voting on my behalf. I'll do it for myself. The other alternative that some people don't know of because it comes from Chapter 617 instead of Chapter 718 is written consents in lieu of a meeting. That can be used unless it's prohibited in the Articles of Incorporation. And it's basically a document that says, hey, we're just going to consent instead of having a meeting to vote in this amendment. Okay. It's good for 90 days from the date the first executed written consent is received. This can work for board meetings and member meetings and most things that you would vote on unless the Articles of Incorporation say you can't. Okay, so the board or the members can use this. You just determine which group gets to sign these based on when the what type of meeting is being held that this vote is taken at. Okay, elections. Pro tip, avoiding disputes over the validity of the election result. Just close the balloting at some point. A lot of people will say ballots can be submitted from this date to this date at this time. Usually that's going to be maybe 15 minutes after the election meeting starts or possibly like 5 minutes so that hopefully you've got all of those ballots in and you can start counting them right away when the election meeting actually starts. That way you're able to actually leave at some point and have an election result rather than technically being obligated to continue taking those ballots for the next 20 hours or however long. Okay, there's no quorum requirement at an election meeting, but at least 20% of the eligible voters must cast a ballot in order to have a valid election. So if you don't have at least 20% of the people that are eligible to vote voting at the election, you didn't have an election. And if you do not have enough ballots and you're not able to take those proxies, let's say, your 15 minutes after the election started is up, you've closed the balloting, you don't have 20%, that's the end of the meeting. Your board just carries over. There's no point in sitting there. You can count how many ballots were received. And if it's less than 20% of the eligible voters, meeting's over, you're done. There's no election. The board just carries over. Okay, the condo election process is regulated by Chapter 718. It's also regulated by the Florida Administrative Code. But basically the system, and I'm going to go through all of this a little quickly. You've got 4 dates that are relevant. 60 days before the election, you need to mail a first notice or electronically transmit a first notice of the date of the election to every member. Anyone that wants to be a candidate needs to submit their notice of intent and give written notice of that intent to the association at least 40 days before the scheduled election. Okay, if they want, they can submit an information sheet that's 8.5 by 11. It needs to be supplied to the association by the candidate at least 35 days before the election. And it's included when you're mailing out your ballots and all your envelopes, et cetera, to the members to actually vote. Okay, there is no change by the association. Even if you don't like what's in this form, you cannot change it. You can request that the person withdraw it. You can point out that it might be defamatory if it is false, if it contains false information that impacts someone's reputation, finances, etc. But you can't change it. You still submit it. You still send it out with everything that goes out. Now, when that goes out is 14 days before the annual election meeting, together with the written notice and the agenda for the meeting. You send a second notice of the election, together with the ballot that lists all candidates alphabetically by surname. In that, you're also going to include all of those information sheets, and you're going to include the envelopes and ballots. Okay, so let's see. Whoever gets the most votes wins. Vacancy is caused by expiration of a term. That's filled by a new election. A vacancy caused by resignation is filled by appointment or another election. Use the appointment if that's possible, so that you're not sitting there having to hold another election, spend the cost of another election. What's the point? If you can appoint someone, they're on the board after one board meeting instead of having to hold another full election. Election by acclamation, if there are fewer or equal vacancies as compared to the number of candidates. In other words, you've got 3 open slots based on the terms expiring, and only 2 people new want to be on the board and have submitted their nominations and submitted their names for candidacy. Why would you hold an election? Those 2 people are on the board. Done. End of story. The official records, all the ballots, sign-in sheets, envelopes, and other papers regarding the vote are kept for 1 year from the date of the election, or until the next election, if that's later than 1 year after. Any challenges to the election process need to be commenced within 60 days. 60 days meaning 60 days after the election results are announced. Anything after that, subject to dismissal. That challenge is done. This challenge, by the way, I did get one recently. It's not just we send an email saying, I challenge the election. That's like on The Office where Michael Scott says, I declare bankruptcy. Okay, it's funny. It's great, but it doesn't legally mean anything. You have to actually send notice that you're going to file a petition for arbitration regarding the election result, or that you're going to file a lawsuit, and then you need to file one of those 2 things within the 60 days. Otherwise, that lawsuit, that arbitration petition should be dismissed. Candidate is literally anyone that's eligible and has timely submitted the notice of intent. Okay, anyone that wants to be eligible, or anyone that wants to be a candidate must be eligible not later than 40 days prior to the annual meeting. In other words, as of the date that they need to be nominated, they need to be eligible. If they're not, you can't just jump in after the fact. Okay, the reasons that you might not be eligible, it's generally anyone is eligible. The reasons you might not be is you're convicted of a felony or something that would be a felony if convicted in if it occurred in Florida, and you haven't been let out of prison for at least 5 years as of that 40-day time frame. If you've been suspended or removed by the division under the Condo Act, in other words, it's not just a recall, you've been actually removed. You're not eligible. Person who's delinquent in payment of any assessment due to the association as of that deadline is not eligible. And if you have more than 10 units in a residential condo that doesn't include timeshares or timeshare interests, co-owners cannot serve as members of the board at the same time unless they own more than 1 unit or no one else wants to serve. Anyone that serves as a board member who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation is also abandoning their seat. In other words, it's not optional. The board doesn't get to say, well, we like Jim, but he hasn't paid for 15 years. No, Jim's off the board, period. Okay. So these timeframes are very specific. the 5-year time frame, the 40 days, you need to be very specific because people will contest this and they will have a problem with being left off, even though this is a volunteer position and a lot of work for no thanks. But there are people that are very adamant that they need to be in control and make sure that everything is running properly. So the number of directors, unless the governing documents say otherwise, you have a 5-member board. Condos with 5 or fewer units, obviously you don't have everyone on the board, that's 3. The term expires at the annual meeting and you stand for re-election unless it's prohibited by the bylaws, or it's a timeshare non-residential condo, or if the staggered term doesn't expire, or if all directors' terms would otherwise expire and there are no candidates. In other words, you roll over. There are 8-year term limits. That is not kicking in officially yet because it's not being deemed retroactive. It will, I believe, in the next 2 or 3 years. I don't recall exactly what year this came into place. I think it might have been 2018. So let's see, if it's 8 years, 2018, again, I'm not really good with math, but it looks like that's 3 more years before that becomes an issue. And then again, we talked about co-owners can't serve together unless it's a small condo or there's no one else that wants to. Okay, the process, I'm going to go through this really quickly. When you are at your election meeting and you're actually counting the ballots, here's how it goes. You've got an outer envelope that contains the name of the signature of the person voting, preferably their information, in other words, the unit number or address, etc. It's identifying that this person actually has the right to vote and didn't already vote. If they only own 1 unit and they voted more times than they're entitled to, in other words, they submitted 5 envelopes of these outer envelopes, but they only own 1 unit, all of those are no good. All of those envelopes, you mark disregarded or disqualified, move them to the side, and you don't count them. Once you've made sure that you've marked off and everyone that's tried to vote is entitled to vote, keep in mind voting suspensions will impact that too. If everyone that's tried to vote is actually entitled, you'll move along, and the next step that you'll do is open up those envelopes and check to make sure that there's only 1 inner envelope inside it with no markings on it, okay? Preferably no markings, okay? If there's more than 1 inner envelope, you're going to check your roster and see if that person owns more than 1 unit. If the answer is yes, make sure that the number of times that they attempted to vote, meaning the number of ballots they're submitting, matches the number of votes that they're entitled to in the community. Okay, so if someone owns 50 units, yeah, they get to vote 50 times. If you don't have any issues there, and by the way, if someone owns 1 unit and they have 5 ballots, all those are disregarded as well, 5 of those inner envelopes. Okay, once you get through and you're sure that the inner envelopes are all good, preferably they don't have any markings on them, and I say preferably because under most attorneys' viewpoint, that doesn't, the markings don't invalidate the ballot. They just waive the anonymity that you're supposed to be having for who voted for what. That's the purpose of the outer and inner envelopes. The outer one marks to make sure that this person's entitled to vote in the first place. The inner one marks to make sure, okay, this is just a ballot. It's someone who was entitled to vote. We no longer know who it is. If you wrote your name on there or your unit identification, you're just waiving that anonymity. Okay, so you pull the ballots out, you make sure that everyone that's voted has the right amount of votes. Let's say you've got 3 open positions. If someone votes for 4 individuals, well, I'm sorry, but that ballot doesn't count either. It's disregarded, okay? If they voted for 2, that's totally fine. They don't have to vote for all of the open positions. They may not know people well enough. They may not care. That's their prerogative. It's only if it's too many votes that you can't tell who they intended to not vote for or they're not entitled to vote for. So you mark that disregarded. Now you count up all of the votes for each of the people with the ballots you have left, and whoever gets the most votes wins. That's the entire process. But again, close off the balloting before you start counting so that you're not having that process interrupted by people continuing to submit ballots. So my suggestion, cut off the balloting at a certain time. That time is exactly when your volunteers start counting. Okay, so the officers, these are literally just the people that the bylaws say you're the president, you got the potentially the vice president, secretary, treasurer. They're generally selected by the board at a meeting that's held immediately following the election meeting. The board gets to vote by secret ballot if they want, or frankly, I've seen it where everyone just says, John, you want this position? Yes. Does anyone else want it? No. Okay, that's your position. That type of situation. There's no prohibition against changing officers midstream. So something we've seen, if your president has gone rogue and is just signing paperwork willy-nilly, whatever they want to do, they think they're entitled to do it, which, by the way, they're not unless that power has been delegated to them by the board. So the board is authorized and gives the authority for what the association is allowed to do and not allowed to do. Without a board meeting, you don't generally have a decision. And that means that that president didn't have authority to do anything without a board vote. Just because they're a director, just because they're an officer of the community, doesn't mean they have the right to do anything special other than vote at board meetings. Okay. So if that person goes rogue, decides to do whatever they want, the rest of the board can vote them out of that president position and either take them off of the officer's roster completely or put them in, let's say, a different position like the secretary, who doesn't have the authority to automatically sign all association contracts, paperwork, send out demand letters, etc. Electronic voting, I won't go into too much detail about, but it can be extremely useful. There are many vendors that we work with that do a fantastic job. It tends to result in additional costs in exchange for getting people to actually show up, because if you can vote from your phone, it's a lot easier than getting a piece of paper, having to fill out a proxy form, or having to show up at a meeting physically, or frankly, even attending on Zoom. If you can sign at any time just by clicking through, a lot of people, especially in younger age groups, are going to be more apt to go ahead and move forward with that voting process versus just not showing up. Okay, so we'll skip the rest of electronic voting. Again, I think Jeff mentioned it earlier. If not, please understand you're going to get these materials, or at least have access to them, at the end of the class. So if I'm flying through something, don't misunderstand and think, oh my goodness, he skipped that, I'm never going to learn it. No, you'll get the materials. You're welcome to read it. I already told you you're welcome to email me anytime if you're not sure about any of the information that's covered in this class. At the end of the class, we'll also send out a survey. If you have questions and you want me to reach out regarding representation, what some people will do is say they want me to reach out regarding representation, but really they had a question that they wanted answered. That's totally okay. Okay, but if you mark yes on that, do you want an attorney to contact you? Guess who you're hearing from within the next week or so? This guy. All right, so moving forward, now that we've clarified that point, your board of directors, you wear many hats in your community. Most people that are on this will probably either be a manager or will be a director of their community. So who does what is the big question. Well, the members are just the owners. They don't really have a lot of rights other than to vote at member meetings. The board is actually the same, even though they have a lot of control over what the association does. These are your directors. Their job is to attend board meetings, make motions at board meetings, second those motions, and vote on those motions or abstain if they have a conflict. That's all directors do. It's a very important job, don't get me wrong, but that's what the directors do. The officers do whatever the bylaws generally tell them to do, although we all know what a president does for the most part, what a treasurer and a secretary do, etc. Keep in mind also, if you've got a property manager, which I generally recommend if you can justify the expense, by the way, you can justify the expense. That manager is going to take on most of the responsibilities of your of your secretary, your treasurer, and your vice president. So when you have a manager, your president is really the only person on the officer side that has major responsibilities. And that's usually just going to be to sign off on things and communicate with the manager. So moving on, this is probably the most important slide of the entire presentation. The board of directors owes a fiduciary duty to the association as a whole. Okay. What this means is the board, the directors, are the equivalent of a trustee of the community. This is the highest duty that Florida law imposes on anyone. Okay, so this means you've got the obligation to do what's in your view, what is in the association's best interest, even if it hurts you. Okay, so you need to put your best effort forth to make sure that you are doing what's right for the community, even if it's bad for you. Okay, this is where we're getting into conflicts of interest, things of that nature. Now, the good news is directors can be, well, not the good news. We'll get to the good news in a second. Directors can be held personally responsible for a breach of that fiduciary duty if they do something wrong. Now, the good news, you're most likely covered by directors and officers liability insurance. If not, immediately order that and pay for it and make sure that these people are covered. They're volunteers. They shouldn't be subjected to individual lawsuits for things they did as directors unless it's malicious or something that would, frankly, violate the indemnification provisions of that insurance policy and possibly of your governing documents as well. That directors and officers liability insurance is probably your second or third most important. Obviously, first is your attorney. Second is if you have a manager. And the third is directors and officers liability insurance, because all three of those people or all three of those expenses are to protect the association and its directors and officers from, frankly, screwing up or being held liable if they do screw up. Okay, so you want to make sure you've got that insurance. You want to make sure you have an attorney and a manager, if you have a manager that you're comfortable with, that you trust, and that are going to communicate with you when problems come up. Okay. Directors can't be compensated in a condo unless it's otherwise authorized in the bylaws, unless it's for work that you're actually performing for the association. In that event, it's conflict of interest and it needs to be disclosed, and you need to abstain from the decision regarding that particular project when the board votes whether to go with that company or not. Okay. Again, the other good news is that even though you have the highest duty imposed by law, it's judged by what I call the dumbest guy in the room standard. Okay. You'll excuse me, but that's the reality. If you reasonably believe that whatever you were doing, however dumb it might have been, was actually in the best interest of the association, the business judgment rule protects that judgment. It's business judgment. The business judgment rule will protect you from liability, whether it's raised as a defense in that lawsuit or in that claim or not. Okay. So yes, high standard, but low threshold for your decision-making capacity. Okay, again, corporate powers are exercised by the board. Board gets to make decisions, not the officers, not the members, unless the members are entitled to make the decision under your governing documents or Florida law. So we talked about unilateral decisions. The board is responsible for the maintenance, operation, etc. of the association property. So you're responsible for the health, safety, and welfare of everyone in your community to the extent that they might enter onto common areas. In a condo, that's even more important because the common elements can actually impact, the units themselves. That's a dangerous game to play. Okay, when does a meeting of board members become a board meeting? Anytime, by the way, let me step back. There's no such thing as the sunshine law in Florida condos. That is purely government. Okay, you are not government. You are a condominium. You are regulated by government, but you are not government. So when someone says, well, the sunshine law says X, make sure they're referring to chapter 718 and not the sunshine law, which is not applicable at all. So board meeting is anytime a quorum of directors is conducting association business. Now there's question whether discussing association business is a board meeting. My opinion has always been it's generally when you're voting on things and making decisions. That said, if you're going to have that discussion and not make the decision, you have to hold that discussion again when you have the board meeting. That's part of the board process. That's part of the board voting process. So for example, if you have a 5-member board, 3 of you are out for happy hour dinner, you start talking about the association spending money to throw a party at the clubhouse. Well, technically that's association business, and you should have notified the entire membership, who then have the ability, like we discussed with respect to member meetings, to attend, record, speak at, etc., that unintentional board meeting. The same thing applies to committees, by the way. If the committee's meeting and it includes a vote on whether to spend association funds, or there's any kind of architectural review body in your community that is meeting to make decisions on architectural modifications. The board is allowed to email as a means of communication. You can communicate by email, but you can't vote on association matters via email. Now, the exception to this is if you use a written consent. We talked about this earlier. You can email around a written consent to be signed. You just can't make an actual vote. That written consent replaces the need for a board meeting. So you're not holding a board meeting unofficially via email. You're not voting via email. You're voting via the written consent in that circumstance. Okay. The other thing, if someone screws up, they should have gotten a board vote, but they forgot, or it was an emergency, you can ratify that decision after the fact. I don't necessarily suggest using that as your regular course of action so that you only have to have a board meeting once a quarter, but it is an option if there is a true emergency. And then we talked about the president just going ahead and taking actions. There is apparent authority of the president, unless you've placed everyone that you might contract with on notice, that the board needs to make these decisions, or that there is a second director sign off required. A lot of times that's the secretary that also needs to sign all checks, all contracts, things of that nature. So that might be a way, if you don't want to remove the president, but they are kind of going rogue, to get them under control a little, is requiring that second signature of someone else to ensure that what's being done is actually what the board would want, not just what the president or someone else in power would want. There's no such thing as a free lunch. A director, officer, or manager can't solicit, offer to accept, or accept any goods or services for value for which consideration, dollars or some other remuneration, hasn't been provided for their own benefit or that of their immediate family from anyone providing or proposing to provide goods or services to the association. There are civil penalties and criminal misdemeanor penalties if you are found to have done this. There's no prohibition against these people accepting services or items in connection with trade fairs or educational programs like this one. That's why when you show up to the Orlando or the Tampa or the Broward, Palm Beach Condo and HOA expos, you're allowed to accept our pens, paper, our goofy balls that Jeff and I throw at each other throughout the day, etc. So that stuff is all acceptable. It's just because it's in connection with a trade fair, or if we were to offer lunch today, if anyone was appearing in person in my office, that's acceptable because it's in conjunction with an educational program. I wouldn't necessarily suggest that you provide Ruth's Chris as that lunch, but pizza or something of that nature, Panera, that's acceptable. Guilty until proven innocent. If you're charged by information or indictment with a felony theft or embezzlement offense involving association funds, you are removed from office. The vacancy is filled until the end of the suspension, which occurs when you are found not guilty by a judge or the charges are dropped, or the end of the director's term, whichever occurs first. So if that criminal case takes 8 months and your term is up 3 months into this removal, sorry, but you're off the board. And because you're the subject of these criminal proceedings, you won't be able to get back on during this term. You can try again next year. The director shall be reinstated for the remainder of the term if they're found not guilty. So keep in mind, if someone else stepped in and this person was found not guilty, that person that stepped in is now off the board automatically, and this person is back on. Okay, notice of board meetings. You're going to provide 48 hours posted notice, except in the case of an emergency. When I say posted, I mean literally posted in a conspicuous location on the condo property. In an HOA, what I've seen done, usually in the condo, you'll have like a bulletin board or something. In an HOA, what we tend to see happening is that gets posted literally on a stick or at the clubhouse. But I've seen it literally on a stick with poster board, handwritten in black marker, board meeting to be held in clubhouse on this time at this time on this date. And now, just like you guys in a condo, HOAs are going to have to post an agenda. You can just staple that agenda to the back of that poster board if this is the way you decide to do it. Or again, you can just place it on your bulletin board. Either way. If you're having non-emergency special assessments or amendments to rules regarding unit or parcel use, that's at least a 14-day notice. Even though it's a board meeting, it's still additional notice so that people have the time to figure out how to get there if they care enough to show up. Those notices need to be, these 14 days notices need to be mailed, hand delivered, or electronically transmitted if they accept it, and posted conspicuously, just like the 48-hour notice. And again, you need an affidavit to show that this was properly noticed with respect to each one of these meetings. So again, protect yourself, have the evidence available for your attorney in the future if anything ever gets questioned. Okay, board meeting notices must identify all agenda items except in an emergency. An item not included in the notice can be taken up on an emergency basis. In other words, if it's not an emergency and it's not on the agenda, it's not being considered at this meeting. Notice of any meetings where regular or special assessments are considered need to specifically state that assessments are considered. We discussed this earlier, as well as the estimated cost and description of what you're using the money for. And then if 20% of the voting interest petition the board to address an item, the board needs to do so within 60 days. In other words, it gets placed on the agenda at the next board meeting or at a special board meeting within those 60 days. Just like at member meetings, members have the right to participate. I'm not going to read this in detail, but it's the exact same situation as a member meeting. They have the right to be there, speak, etc., but you can have your written reasonable rules governing frequency, duration, and manner of member speech at meetings. A quorum of the board is a majority, and yes, I'm going quickly because we're now halfway through the presentation and not halfway through the slides. We are going to be able to skip some though, like I mentioned earlier, so we'll get there. When any of the board or committee members meet by phone, those meeting by phone and now by virtual medium are also counted as part of the quorum and can vote that way. A speaker needs to be used or the meeting needs to be broadcast so that everyone that's entitled to attend, including the members, gets to hear what is being discussed. So you can't hide behind Zoom unless you have one of these closed meetings that I mentioned earlier with counsel regarding potential ongoing litigation or regarding employment decisions. Board members can appear by video or similar real-time communication as long as that speaker is used and everyone can hear the electronically appearing board member. There's no such thing as a workshop. It doesn't exist. You either have a board or committee meeting or you don't. So if it's not a committee meeting, if it is a committee meeting, you provide the required notice. If it's not, then no big deal. Move on. You don't have to provide the notice. But it's either one or the other. There's no in between. So again, we discussed committee meetings where there are budgets and final action being taken on behalf of the board or recommendations to the board. They are always subject to notice. They cannot be exempted. In other words, you have to provide notice. Budget recommendations, meeting or committee that don't take final action or make recommendations can be exempted from mandatory notice only if they're exempted by the association's bylaws. So if the bylaws say you don't have to provide notice of this meeting in those particular circumstances, then you don't have to. Conflicts of interest. There is a rebuttable presumption of a conflict if any of the following occurs without prior notice. A director, officer, or relative, or one of those people enters a contract for goods and services directly with the association, a corporation or other business that person has an interest in or conducts business with the association or proposes to enter into a contract or other transaction with the association. These are all conflicts. They need to be disclosed. Now, keep in mind, conflicts of interest are not always a bad thing. Sometimes it's great. You might get a great deal on this landscaping contract, this painting contract, this tile in the clubhouse or in the lobby. Great. You might get a great deal on it. Doesn't matter that it's John's cousin who John's on the board. It doesn't matter. That's not a problem. The only thing you have to do is disclose it and say, I still think we're getting a great deal. John, by the way, he's allowed to show up at the meeting where this is being voted on. He's allowed to explain that he's got the conflict. He's allowed to even promote the contractor. The only thing John can't do is enter into the discussion when the board starts discussing this potential contract and enter a vote. He needs to abstain from the voting. So he actually needs to walk out of the room or shut down the Zoom, so to speak, when this is being discussed and voted upon by the board. He can be there for all of the member statements, but we don't want that undue influence on what the board decides. So approval of that contract requires a 2/3 vote of the other directors present at that meeting, meaning it's a supermajority vote instead of just the regular majority of a quorum. The next meeting, of the members, the existence of that contract and the conflict needs to be disclosed, and any member of the association can request a majority vote of the members present to cancel the contract. If that's canceled under that provision, the association only pays the reasonable value of what's been provided up to the time of cancellation. If there's a termination provision, liquidated damages, or other penalties for early termination of that contract in the contract, doesn't matter. The association doesn't have to pay it. For that reason, we suggest directly referencing the statute that I'm talking about right now in the contract itself, so that there's no argument that this person who decided to contract with the association was on notice of the risk that, well, it could be terminated. We can't say whether it will be or not. If the board votes against the proposed activity, the director can't try again and needs to notify the association through the board that they won't try again to get this contract in place, or they can continue trying to push the contract forward, but they need to withdraw from office. Okay, so they're off the board and they're no longer an officer. Anyone that is in violation of this notice requirement or the attendance at the decision requirement is off the board, and the vacancy gets filled in accordance with Florida law. Okay, we talked about conflicts. We talked about all this, so we can skip it. Relative here, by the way, when we talk about who you need to disclose a relationship with, it's the third degree of consanguinity. Stated in plain English, that means your spouse, children, parents, siblings, grandchildren, uncles, and aunts, and grandparents. Okay, so any of those people, if you have a relationship with them, it is a conflict of interest to do that business. You just need to disclose it, and then you can move forward. Let's see. If it's not properly disclosed, the contract is voidable. In other words, the association can say, yep, we're canceling this. You didn't tell us about this conflict. We could have maybe gotten a better deal. We didn't know. It terminates in that event upon the filing of a written notice terminating with the board of directors, which contains the consent of at least 20% of the voting interests of the association, meaning 20% of your members, less those that are suspended from voting. There are criminal penalties for a lot of different things now, thanks to some of the things that happened down in Miami that are fortunately no longer going on. But because of some of the things that went on in South Florida, some of it is still going on. Some of it is going on in Tallahassee. Some of it has been heard about in Orlando. I'm not trying to single anyone out, but the Miami events were the specific reason for this legislation. If you forge a ballot envelope or voting certificate, if you steal or embezzle funds of the association, if you destroy or refuse to allow inspection or copying of an official record of the association within the time that's allowed by law in furtherance of a crime, that's tampering with physical evidence, or obstruction of justice. And then also, like we mentioned earlier, getting things for value that you shouldn't have. In other words, kickbacks. That was the real thing that was going on primarily in Miami. All the other ones are throughout the state, but this was primarily Miami-Dade County. I won't name any names, but I know that there were some criminal prosecutions back then as well. Now, if a criminal charge is pending against the officer or director for any of these things, the person can't be appointed or elected while that charge is pending, and the association doesn't have to give them access to any records of the association except per court order. If the charges are resolved without a finding of guilt, that person gets reinstated like we discussed earlier. How to get off the board: you resign, you get recalled, you are delinquent in payment of monetary obligations for more than 90 days, criminal charges involving theft or embezzlement of association funds or property, violating the Condo Act, that's done by the division, and they can levy fines as well. That's not necessarily that the board does anything other than maybe a member reporting those violations. Failure to satisfy the certification requirement that you're all resolving today, that's a suspension, not a removal. And the other one is, frankly, death. Okay, let's see. Moving along, budgets. Bottom line, you can't mess around with the budget. You got to do exactly what the association is actually going to need in your reasonable estimation to properly maintain and operate the community up to the standards set forth in the declaration. If you're not doing that, you are not complying with your fiduciary responsibility. You are required to tell the members in your estimation, because you're the one that has the information readily available, what it's going to actually cost. If that means your assessments need to go up, especially with some of the reserves that we're going to talk about, and they might need to go up significantly, that's what you got to do. The members get to propose an alternative budget if they don't like what you're proposing. So if they don't like it, let them propose that budget. You comply with your fiduciary responsibility as a director, do things the right way. And I don't even care if you tell the members, hey, if you guys don't like it, we don't like it either. You're welcome to propose an alternative budget, but we have a legal obligation to do this the way that's going to cover all of the reasonably anticipated expenses for this community throughout the year. You know, sometimes you got to budget for bad debt. If you know that there are people that are not paying their assessments and you don't expect them to pay, one, you should be using a law firm to collect that money so that you can use that money for other purposes, since you've already laid it out for something. Otherwise, it wouldn't be in your assessments. But don't back into your budget and do just what's in there. Don't under budget on purpose so that the board looks good. I understand everyone wants to be reelected. I'll never understand why. But the bottom line is, if you're under budgeting, what you're doing is guaranteeing that you won't have the funds available to do even what's required, let alone what might suddenly pop up in an emergency situation. All right, we talked about all of this. Oh, also when you under budget, and this is something I'll be talking about at the Condo Institute for other attorneys in our field in Florida in September, but you end up with a crisis where you either need to figure out how to fund loans, special assessments, and then you end up with a lot of people that can't afford to pay what you are suddenly requiring because you didn't maintain this thing for 5 years that now costs an extra $10 million to maintain. So take care of it when you're supposed to, maintain things the way they're supposed to, and they'll last a lot longer. And overall, even if your assessments increase, the overall cost of the association goes down over time. And if you need an emergency backup plan, what ends up happening is you have a lot of people on fixed incomes in Florida, and you have a lot of people that are just not earning enough to pay these huge increases, and you end up with a lot of foreclosures, which we obviously don't want to see. So these are just things that go into the budget. I'm not going to read through them because we have a lot to get through. The budget is adopted by the board. I have a lot of people saying you need to have that adopted at your annual meeting. No, it's adopted by the board. The board doesn't get to vote on anything except as members during the annual meeting. So your budget gets adopted at a properly noticed board meeting with 14 days written notice. And a copy of the proposed budget goes along with that written notice, by the way. The person that's providing notice does the affidavit that we mentioned. Notice of any meeting, including assessments, needs to state that assessments will be considered, provide the nature, etc., which we discussed earlier. If the board makes a change to the budget during the budget meeting, it doesn't need to resend or renotice the budget meeting. You just move forward with the new budget. That's it. Special assessment is basically anything other than a regular assessment, by the way. I know I've used the term a couple times. Just to be clear, we're talking about all other assessments. You might have different terms for it in your declaration. I've seen individual assessment. I've seen management assessment. There's a lot of different ones that might be described in your declaration. Anything that isn't maintenance, regular maintenance, is generally a special assessment. Board has to adopt the budget at least 14 days before the start of the fiscal year. If you don't do that a second time, it's deemed a minor violation, and the prior year's budget continues until the new budget is adopted. I'm going to skip some of these reserve terms. You can read through this because we're not going to take a lot of time on reserves because, frankly, my strong recommendation I will make again. Jeff already put it up in the chat, but read through Jeff Rembaum's, and by the way, different Jeffs, but read through Jeff Rembaum's association roundup and specifically his legislative update, because there are a lot of changes with respect to reserves. There were a lot of changes last year. I was on a task force to try and clean up the statute. My colleague Allison Hertz was pretty much in charge of that task force and did a fantastic job. Has really pushed through some important changes. There are a lot of glitches still in the current legislation that was passed this year, but we're starting to get to where it kind of makes sense. So again, I would suggest instead of us spending another half hour on reserves, which frankly, we could spend 2 hours on reserves and not explain everything in full detail right now that is going into last year's and this year's statutes. I'm just going to explain in general terms what's required and how this works. The budget needs to include reserve accounts for capital expenditures and deferred maintenance, including but not limited to roof replacement, building painting, pavement resurfacing, and anything else with a deferred maintenance expense or a replacement cost of over 10 grand. Now, this is now a nice big mess because we've added a whole bunch of things that you now need to reserve for. I'm going to name them. Again, I won't go through the detail of these reserve studies that are now required, et cetera, but I will clarify, read through Jeff's roundup because the bottom line is there's a lot of information in there. And it's just extremely helpful for you to understand some of the changes that were made. And again, he writes it in plain English, but some of the newer reserves that kicked in last year were the roof, the load-bearing walls or other primary structural members, the floor, the foundation, the fireproofing and fire protection systems, the plumbing, the electrical systems, waterproofing and exterior painting, windows, anything, and then the same $10,000 figure, the failure of which to replace or maintain such items negatively affects any of these previously mentioned items. In other words, you got to maintain anything that impacts the structure or the legislature thinks impacts the structure of the building. This all came about after the building collapse in Surfside, Florida a couple of years ago. But again, there's so much that goes into this. I'm not trying to put it off to say it's not important. I'm saying it's important enough that you need to read through this legal update in detail and not just get a little bit of information from me. Computing reserves, you're basically going to take the value of the component, in other words, what it's going to cost to replace or do that deferred maintenance. When we say deferred, I mean that it's not going to be something you do every year. It's every once in a while. You're going to take that replacement cost or deferred maintenance cost and shove it into a formula that compares the deferred maintenance cost or replacement cost to the estimated useful life of that item. So when you say, let's say this is a $10,000 or $100,000 roof, I know it's cheap, good for you. You're going to re-roof your clubhouse, okay? And when I say cheap, I mean for a building, not a lot in an HOA. But the roof has a life expectancy of 10 years. It costs $100,000 to replace the roof. Okay, great. That's a pretty short lifespan, but we'll run with it just for purposes of the example. That means that as of right now, if you know that the cost 10 years from now is going to be $100,000, you're going to reserve on a straight line method at least $10,000 a year so that in 10 years you have your 100 grand. Okay. There's a little bit that needs to be changed there though, because, oh, that's right, inflation happens. Okay. Prices change. The cost of labor is going to change. The cost of materials is going to change. Possibly from the time you sign the contract to the time the work's done a week later or a month later or 6 months later, whatever it may be. Okay. That re-roof might take a little while. And during that time, the cost of materials might change from the time you start the project to the time you finish it. Okay. So you can account for that by doing a reserve study every once in a while. A lot of communities do 2-3 years, some do 5, some just adjust for inflation. But you're doing an updated reserve study to find out, okay, has the estimated price of that work changed? Has the expected life of that asset changed? If the answers to either one of those things are yes, you then adjust that straight line that, let's say you're in year 3, you've got 30 grand in the bank, but it's going to cost you 120 to do the work that's going to be needed. And it's only going to be in year 9. So you've now got 6 years left to save $90,000. You take your 6, you divide it into the $90,000, and the dollar figure you come up with is what you have to reserve every year now. Do the same thing 3 years later, find out, okay, great, things went well. You shift again. So You can have a reserve study done and adjust this as often as you'd like. Frankly, you probably can't do it more than once a year, and it probably would be cost prohibitive to do it more than every 3 years or so, but it is an option. The other option for reserves is to keep them in a pool where you basically reduce the amount of the reserve budget and therefore reduce the amount of the assessments. In that instance, you basically have enough to cover each item as of the date it's expected to fail. You're not just saving everything and you're not saving it separately. Okay, you're just shoving all that money in one bank account. You use it as needed for those reserve items. You're still limiting it to a pool of reserve components or pool of assets that need to be replaced or repaired. The difference is you're not just saying 100,000 for this, it's 10 years, so we reserve 10,000. That's it for that one. Now we move on to the pool. That's another 100,000. If that's going to last 30 years, so we divide that 100,000 by 30, and that's what we get for the pool. We save that separately. This is, we have the pool and the roof. We're saving the money all together in one account. Okay, so that's probably all I'm going to say on reserves, because again, there are a ton of things that go into this. Your budget needs to include, I was wrong. I will say more about it. Your budget needs to include fully funded reserves, unless the reserves are waived, if that's possible, depending on what the DBPR decides and the legislature decides, or reduced by approval of a majority of a quorum of the owners. So you can put away less money than you thought you needed before if a majority of a quorum of the owners vote in favor of saving, basically not paying those assessments this year. The board gets to put that issue to a vote of the members. You don't have to. That's totally up to the board whether you want to even consider holding off and not putting the fully funded reserves into the budget. If you're allowed to waive, again, if you're allowed to waive or reduce. The other issue is if you want to use the funds for some other purpose, if it's in a pool, you probably can. If it's in a straight line, that's also going to require a member vote. Okay, that's the next slide. Okay, there is specific language that needs to go into the proxy when you're voting on your use of reserves differently. This is it. And if you have your financial reports, they also need to include specific language depending on what reserves you're maintaining. But members are entitled to financial reports. They need to be prepared at least, or provided at least 21 days after the financial report is completed by the association, but not later than 120 days after the end of the fiscal year. So this is where, pardon me, your manager is going to be coming in handy. They're probably going to know all these timelines and what needs to happen, what doesn't. If not, then I hope you're using an actual CPA who can basically do all your accounting for you. If you're doing it all yourself, then you might want to just reach out to counsel, but there are financial reporting requirements for condos. Just because you're a not-for-profit doesn't mean you don't need to maintain financial reports. There are also different levels of reporting, but every year you do need to have a financial report. Okay, we'll get into the levels right now. These are the levels that are required. Basically, it's mo money, mo problems. The more money you're bringing in, the greater expense that you're going to have to put these reports together, and the greater scrutiny, because let's be honest, you have more money, there's more likelihood that someone's going to get away with some of it. So 150K or less, you've got your cash receipts and expenditures. That's essentially, here's what we took in, here's what we spent. It's a spreadsheet, it's a ledger, that's about it. It does need to include expense classifications for security costs, management charges, etc., but it doesn't require a CPA. It doesn't require any level of actual review of your records. It's literally just, we prepared this, here it is, we're done. Then you get into the levels of greater scrutiny as you go up in dollars. The reviewed and audited financial statements do require a CPA. One thing to remember is that the board can increase the requirements, but can't reduce the requirement. In other words, if you technically needed an audit, you can't do a reviewed statement without member approval. If you needed a reviewed statement, the board can unilaterally decide, you know what, we think an audit's necessary because a previous board messed around with our money, and we want to make sure we find out and we can go after them for it if we find that there was wrongdoing. Okay, these are just things that all board members should be thinking about and know about: how to draft minutes, returning records when you're no longer on the board, etc. These are just things to keep in mind. All board meetings and member meetings should have minutes taken. Meetings don't need to be verbatim records, and frankly, they shouldn't. It's literally, here is the motion that was made in as concise language as possible and as clear as possible. Here's how each of the directors voted. Actually, sorry, let's go back. Here's the motion that was made. Here's who made it. Here's who seconded it so that it could be voted upon. And here's how each member voted. Here's how the one person that abstained or the two people that abstained because they had conflicts. I want to be clear on this. You do not abstain because you don't like what the board is doing. That is not a proper basis to abstain. That's you not showing up and doing your duty. Your responsibility as a director is to vote. If you don't like it, vote no. But just because you don't like the two options doesn't mean you get to say, I'm just not going to show up on this one. You abstain only because of a conflict, not because you don't like it. You have 5 days after you're off the board to return all property and records of the association to the association. And anyone that willfully and knowingly fails to do so are subject to penalties imposed by the division. Those penalties are not something you want to deal with. The association has an automatic right to access units during reasonable hours when necessary for maintenance, repair, or replacement of common elements or any portion of a unit to be maintained by the association pursuant to the declaration, or as necessary to prevent damage to the common elements or to a unit. And you can access abandoned units under certain conditions. So this means if someone has a mold infestation, you get to enter their unit and make sure that that mold infestation doesn't spread to your common elements between units and that it doesn't spread to the adjacent unit. Okay, you've got the right to do that. Anyone that says you're not allowed in, bring the police. Print out a copy of the statute. Okay, that it happens more commonly than I'd like to acknowledge. But the board does have the ability with reasonable hours, not at 5 in the morning to cure a mold issue that you've known about for 3 weeks. But if it's a leak in a unit, then yeah, absolutely, it might be reasonable to enter the unit at 3 in the morning. Okay. Before you treat any unit as abandoned, contact your attorney, and the governing documents might provide the unit owners to provide a key so that you don't have to basically break into their unit, which is generally a bad idea. The association does have the responsibility in that instance for safeguarding the owner's keys and anything that gets damaged in accessing the unit. Marketable Record Title Act generally doesn't affect condominium covenants because the deeds refer back to the declaration and incorporate the covenants every time the property is sold. So the declaration, as it may be amended, is incorporated directly into the deed. You need to let process servers into your building. You must allow them even if unannounced. Sometimes they are trying to reach people who, if it was announced, would no longer be available all of a sudden. So you got to let them in. You can adopt reasonable rules and regulations. We discussed this earlier. You just got to give 14 days notice to the members that you intend to do this. The rules need to be supported by, or at least not conflict with, the declaration of the bylaws or the articles of incorporation. So if your declaration says we don't have rules regarding pools, doesn't contain rules regarding pools, but specifically says you can have a pool, you can't have a rule that says, well, no, we changed our mind, you can't have a pool. You got to amend the declaration in that instance. Maintenance, it's the association's responsibility to maintain everything in the community, at least the common elements, not the units. If the declaration doesn't specify the procedure for material alterations, which is again, changes to the visual aspect of any part of the common elements, 75% of the voting interest must approve. The exception is that under Florida case law, the board can undertake alterations that actually assist the protection of the association. Okay, so what we're talking about, this is Tiffany Plaza is the name of the case that you'll see here. It's a rock revetment wall. What that means is that little wall that you see when you're on a waterway, before you actually reach the sidewalk or the grass or anything like that, you might see stones that are built up as a wall. Well, the purpose of that is to protect that walkway, the buildings adjacent to it, the parking lot, the pool, whatever might be near it, from that water coming over and damaging any of those structures. Okay. If the purpose is protection, even if it changes the appearance of a common element of the association, no member approval is generally going to be required. Okay, we don't need to go through this because we got to skip some stuff. Hurricane protection, the board needs to adopt hurricane protection specifications. This is something that some of our attorneys worked very hard for a very long time on putting into the statutes. I don't know that I need to go beyond. You need to have hurricane specs, and you need to allow people to protect their units to some extent, but you can regulate how. There are emergency powers that kick in anytime a state of emergency is declared. This was changed when COVID hit. It used to be that damage was caused to the community. Now it's you are worried, frankly, about damage in connection with a defined state of emergency, which could be in your local municipality, it could be statewide, it could be nationwide, whatever. As long as it impacts your community and it is declared by some governmental entity, these emergency powers kick in. Unfortunately, this is one of those things that I think you just need to read through, and we'll skip it because we just don't have the time to get through everything. We never do when we do these classes. It's 186 slides. It's just not possible. So I'm going to skip through some of this, but just understand when these emergencies, when the state of emergency kicks in, these are rights the association has. Make this part of your board member emergency kit. Print out just those slides. You'll want to know what you can and can't do. You'll also all of a sudden have the paper in your emergency kit because you can write on the back of my slides. Okay. We will most likely be operational. We will have at least a couple of attorneys, even in the event of an emergency, that are still working. So email me, you'll print out that first slide too. Even in the event of an emergency, I might be able to help you out even if you're not a client. But that should be part of the paper that goes in your emergency kit. You'll want a pen, a disposable camera to take pictures in case your phone dies or your camera dies, walkie-talkies to communicate with the rest of the directors, possibly your manager if they're local, and important vendor contact information to get people to clear debris and salvage whatever needs to be salvaged and repair any damage that might have occurred. Another one that I always add is a couple high capacity external chargers. I have one here that I use for my laptop when I leave the office. It's about 15 pounds and it is not small, but you know what? I'm always happy to have it when my computer my computer battery dies and I still want to continue working. You'll be very happy to have it because that thing will charge your cell phone probably 5-6 times before it dies. And if you have 2 or 3 of those for the community, then all of your directors can charge their phones a couple times so that you can communicate and make sure that the board is doing what it needs to do in those emergencies. Leasing approval and amendments. If you have the ability to do those approvals or rejections of potential tenants, the grounds for disapproval can include, but not limited to, the unit being delinquent in payment of assessments. In other words, if you're not current, you can't rent. You can't gain money from your unit if you're not paying us. New leasing restrictions and rules must be in the declaration and only apply to those unit owners who voted in favor of the new leasing restrictions if they're adopted. So in other words, if you didn't vote for it and you didn't buy in after it took effect, it might not impact you if it's a leasing restriction, even if the declaration gets amended. If the unit owner doesn't vote for it and they pass, the new leasing restrictions don't apply to that singular unit until the ownership changes. So you might need to keep a record of who owned and how they voted once these kick in to determine who is actually subjected to those amendments. Okay, amendments, generally 2/3 vote unless your declaration says otherwise. New language is underlined, deleted language is stricken, but if that would make no sense because of the amount that's being changed, you just put in this text, substantial rewording of declaration, see provision for present text. An amendment is effective when it's recorded in the county public records. If you don't think you can get the vote for amendment, but you feel that it's necessary to do the amendment, start by amending the quorum and amendment provisions, then try to accomplish what you originally wanted and amend substantively. The other thing to consider is, like I mentioned earlier, electronic voting might get you a much better turnout for those types of amendments. Okay, you need to have a licensed manager. Now, when I say you need to have one, I don't mean you have to hire one. I mean, if you have a manager, they must be licensed. If the work is done for remuneration, meaning they're getting paid for it, and the association or associations served contain more than 50 units or an annual budget in excess of 100,000. Anyone that does clerical or ministerial functions under the direct supervision and control of a licensed manager who is charged only with those basic tasks is the way that it really should read, and doesn't assist in the actual management services described above isn't required to be licensed. So if they're doing these tasks, that's when they need to be licensed. Anyone that wants to work with the association can't purchase a unit as a manager, or an officer or a director can't purchase a unit at an association foreclosure sale. So that's the only type of third party that can't buy. Now, what you can do is buy at a mortgage foreclosure sale or a tax deed sale, or buy it from the person that bought the property at any of those type of sales, or an association foreclosure sale. So keep that in mind. If more than half the units in the condo are owned by one individual or entity contracting or to provide maintenance or management services, and it's a residential condo after transfer, in other words, turnover, the contract with the party providing maintenance or management services may be canceled by majority vote of the other unit owners. So in other words, if someone's taking over the whole community and managing it and getting paid to manage it, that management contract can be terminated by a vote of a majority of the other owners. No debit cards in condos. It's not legal. You can use a credit card, but it's treated as credit card fraud to use a debit card for an association. You can use your own and get paid back, reimbursed, etc. You just can't use it in the association's name, or for billed directly to the association. Association can't hire the same attorney who represents the management company. That's why we work with a lot of management companies on behalf of our clients, but our client is always the association. We don't want that conflict of interest, although we're happy to help the management company to do things the right way on behalf of our clients. Okay, it's not clear whether the attorney can engage in efforts on behalf of the current management company in connection with indemnification requirements. In other words, protecting the manager, or if it prohibits an insurance carrier from appointing one attorney or law firm to handle defense of a claim made against both the association and the management company. So these are just some things that are not clear. I point them out not because you care, but because they're interesting to me. Electric and natural gas vehicles, we're going to have to skip through, even though it's important. Again, you're welcome to read these things, but it's a fairly large issue in the slides and does not come up quite as frequently, although it's increasingly frequent now. Disputes, bottom line, go to mediation, don't arbitrate. Okay, it's just easier. You're not going to have to deal with filing an arbitration, going through that entire process over 6 to 9 months or so, and then having to file your lawsuit to enforce the decision. You can go straight to court if mediation isn't successful. So let's go through what this process entails very quickly. You used to be required to go to pre-suit arbitration. Now you have the option in the event of a dispute. Here's what a dispute is. It's described in here. First, you notify the offending owner of the violation in writing. Okay, you basically say, hey, the management company or the association has told you 2 or 3 times already that this is a problem that you need to fix. I'm the attorney for the association. I'm just letting you know you really need to fix it, or they're going to move forward with statutorily mandated action. Then we go, if it's subject to a dispute, which is, here's a list of stuff that's not subject to mediation. But the main thing that we're talking about is covenant violations. Okay, you violate the rules, you violate the covenants, you do something with your property you're not supposed to do. Those are the types of things that we're talking about. So in that event, you send an offer to participate in pre-suit mediation after that first notice. Okay, you're not going to find, by the way, any of this in Chapter 718 other than the opportunity to send the offer for pre-suit mediation, which is listed in 718.1255. But you're going to go to Chapter 720, subsection 311. That's where you're going to find the offer for pre-suit mediation, the disputes that are subject to pre-suit mediation, etc. Okay, the disputes are also defined in 718.1255, but bottom line, you're going to send a letter that says you have 20 days to select at least one of the 5 mediators I've provided in this letter and respond to the request by signing and returning that form that's included at the end of the letter within 20 days from the date that I mailed this to you. If you don't, you are waiving your right to recover attorney's fees and costs, even if you win any lawsuit that we file because you ignored our demands to cure the violation. Okay, The parties must share the cost of pre-suit mediation equally, including the mediator's fee. And by the way, I don't know what other costs would be involved. You're really just sharing the fee, but the statute says you share the cost, including the fee. The mediator can require advance payment of the fees in order to be able to mediate or willing to mediate. So this list here is the disputes that are subject to pre-suit mediation. Use of or changes to the parcel or the common areas, amendments to the documents, meetings of the board and committees appointed to the board, membership meetings, not including election meetings, which are subject to arbitration separately, access to official records, and covenant enforcement, like I said earlier. Okay, if the person doesn't respond or doesn't agree to one of the mediators or doesn't send it back via certified mail, return receipt requested, which is the methods required by law, or doesn't pay the mediator or doesn't show up, you can go ahead and file your lawsuit because an impasse is declared in that mediation proceeding. Okay, you can file your lawsuit to do whatever you intended to do in the first place. I'm not going to get into non-binding arbitration because frankly, the division, the arbitrators that are ruling in these cases generally will reduce the hourly rates significantly of the attorneys involved. So you're not recovering everything, even if you win. Whereas courts will generally award most or all of the attorney's fees unless they're given a reason not to do so. And the arbitrators have expressly stated that they get to decide every one of these cases in an arbitrary fashion, meaning that precedent doesn't quite matter as much as it should when you're going through this arbitration process. It's just less of a guarantee that you're going to get a fair result, and you want a fair result for your community. If you didn't think this was worth pursuing, you wouldn't pursue it. So mediation followed by a lawsuit seeking an injunction is generally going to be the way to go. I mentioned earlier, if you have a self-help remedy, you should use it. I will clarify that according to Florida case law, you have to try to use it before you can seek an injunction properly in court. So that's one thing to keep in mind is before we go forward and file that lawsuit, we want to make sure to send a self-help demand if your declaration allows for it. Okay, we're going to skip some of this. If it's non-binding, it becomes binding if you end up in arbitration because the owner filed a petition for arbitration. These are the circumstances where the result becomes binding and you can then enforce it in court. Okay, we talked about some of the issues with arbitration. Attorney's fees are awarded only if authorized by contract or statute in Florida. Okay, so fortunately, your declaration is almost always going to contain a fee provision, and so do the statutes when it comes to these types of disputes. So keep that in mind. There's also the certified written inquiry. You might need to respond to that as well. That's a separate issue that you're going to want to run directly to your attorney as soon as you receive it. Okay, websites, bottom line, you need to have one as a condo effective January 1st, 2019. If you have 150 more units in your condominium, that might be a multi-condo. It depends how your condo is operated. Okay. The website needs to be independent. It needs credentials. The association needs to own, lease, rent, or otherwise obtain the right to operate the web page, or a collection of web pages, et cetera, where you can host your notices, records, and other documents. Whether to have one or not, if you're not required to, is a tough call. Frankly, I think it's easier to do this so that you can tell everyone in your community when they send a records inspection request, go to the website, log in. We've given you login credentials. If you don't have them, we can get them to you. And all of the information is there. That way you're not required to sit there in a room with someone for 8 hours every 30 days or so saying, okay, you can look again. You can look again. Yes, we'll make these copies for you. Okay, you can look again, which can cost significant amounts of time and money, and not to mention the fact that you need to physically cart around those records if you don't have them digitized. You may need to still provide a computer for anyone who doesn't have the ability to access that. You may still need to provide some other method of viewing if, for example, someone is blind and can't see what's on those. I don't know that that would necessarily apply because if they can't see what's on the computer, they probably can't see what's on the paper either unless you turn it into Braille. But there have been many things like that that come up where you'd be surprised at what associations get in trouble for. So just be cognizant. You might need to comply with certain housing regulations, Americans with Disabilities Act, et cetera. in order to ensure that everyone has the same access to those records. I'm going to skip the rest of websites. You're welcome to read through it, but I just wanted to make sure you knew who has to have one. Your vendor is going to deal with a lot of this information, just like when you're dealing with electronic voting. The vendor and your attorney are going to walk you through a lot of this stuff. I want to make sure we get to all of the things that you really need to know, and no one is going to be able to tell you unless you pay someone a lot of money to tell you. So mobile application, you can use a mobile app instead of a website or in conjunction with a website. If you're required to post the information, you can make it available through the app instead. Official records, we're going to be pretty straightforward. Okay, the official records are comprised, need more coffee, sorry, of this list of stuff. Okay, we're going to skip all of it because look at, let's see, number 14 here. All other written records of the association not specifically listed, which are related to the operation of the association. Okay, so in other words, we got to keep everything, period. That's it. Every piece of paper, every document that's related to the operation of the community, you need to keep it as an official record. The association needs to maintain those official records for 7 years, except that board certifications need to be kept for 5 years or until the person is off the board, and election materials need to be kept until the next election. However, now, effective in 2018, some records need to be kept from the inception of the community. So you're basically your developer documents and your governing documents, and all meeting minutes. You keep those forever now. Bids for work to be performed are 1 year, no longer 7 years after you receive the bid. Renters have the right now to inspect and copy only the declaration, the bylaws, and the rules. So keep that in mind. Just because they're a tenant doesn't mean they don't have any rights with respect to your official records. And there are some records that are not accessible to your members. It's basically attorney-client work product or work product privileged information until the proceedings are completed. I don't agree with that premise, but technically it's what's been held in several DBPR cases, the arbitrations we talked about. I think that privilege lasts pretty much forever. If it was privileged, it's privileged until the board decides it's no longer privileged. Information regarding leases, sale, or transfers of ownership, medical records, personnel records, and association passwords and software allowing for manipulation of data. So in other words, you're going to produce the PDF or printout of the QuickBooks data, not access to the computer system it's on or your login credentials for QuickBooks Online. So all of these things are records not accessible to members. Certain personal information of owners, which the owners can choose to disclose. Consent to disclosure can happen if the owner says, yeah, you know what, you can give this out. And then some good news for once here, inadvertent disclosure. The association is not responsible for inadvertently disclosing information that was included in the official records. You're basically not in trouble for doing so if it was inadvertent. What inadvertent disclosure means, I don't know. I guess it's when you hold the records in your official records and you meant to pull them out, but you inadvertently failed to. I really don't know. And then, so we talked about attorney-client privilege. Only the board gets to waive that. It's basically any record that is that pertains to any of these items here in this big bullet point. Requests to inspect those records, you need to make them available within 10 business days after receiving the request from the owner or their their authorized representative. Now keep in mind, I said or, that's what's in the slide, but in reality, this is now and, meaning that two people can technically inspect the records together as of the changes in the statutes that are listed, I think in Jeff's roundup that we mentioned before that's in the chat. The official records need to be maintained and made available within 45 miles of the community or within the same county as the community. That right includes the right to make copies. I think it's up to 25 pages are free of copies. And then anything after that, the association gets to charge. The association can also charge for the actual reasonable cost. I think it's up to $20 an hour or something like that for the expense of management taking the time to attend the inspection. I'm not aware that the association can charge the attorney's fees for that involvement unless there is an actual legal dispute that's brought after the fact. The tenant has the right to review the governing documents. The association can charge actual costs for preparing and furnishing the governing documents, Q&A sheet, and year-end financials to anyone that requests it, and reasonable expenses for copies of other records. You can adopt rules governing the time, frequency, location, notice, and manner of records, inspections, and copying. So keep in mind, these are all policies that you can put in writing and not have to deal with owners being a pain from then on. You can say that doesn't comply with our policy complies with Florida law. So the ones that I recommend that every community have: official records inspections, your member speech at meetings, which we discussed earlier, how you're going to do covenant enforcement. Are you going to do self-help? Do you have the right to do self-help? How many letters is the association going to send before it gets sent over to council? When are you going to do self-help if you have that right, etc.? And then collection of unpaid assessments. How long are you going to wait before you start to send your notice of late assessment, which we'll get into in a minute? Okay. What is the association going to do? Are you going to turn it over to council right away? Are you going to wait 60 or 90 days? Because if you're waiting any longer than that, you're basically making it harder for people to pay. You're basically saying, let me let more accrue before I notify you that you're delinquent. You think you're doing something nice for people by giving them more time, but actually most people don't seem to realize you're doing them a disservice by waiting more than 60, 90 days to start the collection process. I don't have a problem sending out a courtesy notice before you send a notice of late assessment, but keep in mind, we'll talk about in a minute, that notice of late assessment, that first statutory notice of unpaid assessments, you can't charge attorney's fees for it anyway. It's literally, here's what you owe. So there's no reason to defer that. Okay, going forward, you cannot require an owner who requests to see official records. You cannot require them to show a proper purpose for the inspection or state a reason for the inspection. So it's literally, I want to see the association's records. Okay, that's it. If you don't provide it within the 10 business days provided under Florida law, if you don't provide access and copying of those records, there's a rebuttable presumption, meaning you can fight that presumption, but it is a presumption that the association intentionally, willfully failed to comply with the statute. Anyone who's denied access or unit owner that's denied access, I'd be surprised if this doesn't extend to tenants at some point in the near future, to official records is entitled to the actual damages or minimum damages for the association's willful failure to comply. The minimum damages are $50 per calendar day up to 10 days, beginning on business day 11 after receipt of the written request. I call this the $500 gift that you don't want to give. So this is just email addresses and fax numbers are not accessible unless the owners basically said, yep, you can go ahead and disclose that. There's no penalty if you inadvertently disclose that information. Now, keep in mind, when I mentioned earlier, you got these $500 penalties. There's also attorney's fees and costs if someone decides to file a lawsuit. So that's why a lot of people will pay out the $500 and just be done with it, unfortunately. And then, by the way, the next day, guess what you're getting? Another records inspection request seeking the same inspection that you didn't provide the first time. So they get another $500 every time. So have that policy in place, follow the timelines, move forward. Contracts and bids, we talked about this a little bit. All contracts that are going to take longer than a year to perform for purchase, lease, or renting of materials or equipment to be used by the association in accomplishing its purposes, and anything for provision of services needs to be in writing. Maintenance contracts, in my opinion, should also specify the obligations of the party that's contracting to provide the maintenance or management services, the cost that's going to be incurred for each service, the frequency that it's going to be performed. Is it going to be every week or every month? The minimum number of personnel that the person should be employing. In other words, do you have enough people to actually service all of your clientele? Any services or obligations that are not specifically stated in the contract are generally not going to be enforceable. So if you want them to do work, you got to make sure that it's in the contract, or at least that it is general enough to say any work that you request that's within this range, so to speak. Okay, if the aggregate cost of that contract or that service or that good is going to be more than 5% of the association's total annual budget, including reserves, the association needs to obtain competitive bids. You don't have to accept the lowest bid. You don't have to get bids for professional services such as attorneys, accountants, architects, etc., or if there's no one else in the county that actually does that work. Associations with less than 10 units can opt out of bid requirements if 2/3 of the unit owners vote to do so. and that can be accomplished by a proxy specifically stating the exception from the bidding requirement. So in other words, small communities don't need to bid out projects if they vote properly first. You can cancel a contract that's made by a condo prior to the assumption of control of the association by unit owners, in other words, turnover. That provides for operation, maintenance, or management of the condominium association serving the unit owners. That gets canceled by unit owners other than the developer. So that's a majority vote of the non-developer members. Bulk communication contracts can also be canceled at the next meeting once they are signed. The next member meeting, if someone actually asks for the cancellation, one unit owner asks, and a majority of the voting interest present at that meeting actually vote in favor of the cancellation. If there's no request at that next member meeting after the contract is signed, the contract is deemed ratified for the term expressed therein. There is no obligation, by the way, of the association to point out that that contract was signed outside of the board meeting when it was approved for signature. So, if the members chose not to attend that board meeting, that's on them. If they're not aware of it and they can't cancel it, kind of their problem. Okay, we talked about this. You can't force someone to use that bulk provider. You basically have to give them the opportunity to use whatever service provider they want. But if the resident pays the alternative provider directly for the services. We're going to breeze through assessments and foreclosures. This is actually where I started with the firm in 2010, and just a brief explanation of the process so that we can skip through most of these slides. Essentially, you got your budget. The budget dictates what people are supposed to be paying by way of assessments, either every month, every quarter, every semi-annual period, or every year, or whatever it may be. Okay, if they don't make those payments, the first notice that goes out is called a notice of late assessment. You know what? I will go through the actual slides just to make it easier for you guys to follow along. I'll also mention before we get back into this, the invoice delivery method. If you're going to change it, you need to provide notice to the members, and the members need to actually agree that they are willing to change their method of delivery. In other words, if you're sending coupons and you decide you're going to go fully digital, you might still need to send those coupons to the members that didn't say, yep, I'm good with going digital. So you might have multiple different delivery methods once your budget kicks in as to how you're telling the members what their assessments are. So just keep that in mind. Interest is due at 18% per year, regardless of whether there's any interest in the declaration or not. If you have a lower rate in the declaration, you use the lower rate. If you have a higher rate, that is illegal, and you use 18%. If you have no late fees in your governing documents, no, you're not charging them. If they're in there, you can charge the greater of $25 or 5% of each delinquent assessment installment. If you're monthly, that means once a month. If you're quarterly, that does not mean you can charge $25 per month. It means per installment. So in that instance, it's the greater of $25 total for that quarter, or 5% of that installment per quarter, not per month. Same if it's semi-annual or annual, you're still doing it on each installment. Attorney's fees and costs are automatically due once they're incurred when it comes to collection of unpaid assessments. Statutory entitlement. I love it, because you know what? The bottom line is no one can say, well, you shouldn't have turned me over because I owed a bunch of money, but I was going to pay it eventually. Doesn't work. You're still obligated to pay the attorney's fees and costs. And this next section is why I say I love it. It's very important to note the way that the association must apply payments received. And when I say received, I don't mean sent. I mean, you physically received a check or something of that nature. Deposited or not, that's up to the association. That's once it's received in a lockbox, so to speak, that's when, in my opinion, it should be deemed received. Any interest that accrued to the by the association is paid first, then any late fees that are charged to this account, then costs and reasonable attorney's fees incurred in collection. Incurred in collection is the key word there. It's not just attorney's fees get tacked on to the ledger because you had to do covenant enforcement. Doesn't work that way unless your declaration says so. And then to the delinquent assessment, meaning you're paying everything else before anything gets applied to assessments. So your attorney's fees and costs, yep, we collected those. Still got to pay the assessment. Thanks for your payment. And here's the next great thing. Restrictive endorsements. That's basically when someone says, well, this is, I'm paying the amount of assessments and I don't owe you any interest, late fees, attorney's fees, or costs. So if you accept this check, that means that you're accepting that I'm paid in full. Now, doesn't mean anything under Florida law. I didn't accept this as payment in full. I accepted your payment because I'm legally obligated to do so. Because if I didn't accept your payment and I rejected it, you can make the argument that I've waived my right to recover that payment. And so your account is reduced by that payment, even though we never received it. Okay. So these are important things to consider when you're doing collection. Now, back to the notice of late assessment. This is the actual statutory notice that you need to send out to start the collection process. It's a 30-day notice, goes out via regular US mail, and basically says, here's what you owe. If you don't pay it within 30 days, we're going to move on to the next step. And there will be attorney's fees and costs that we're charging. Some people don't include interest in that. Frankly, that's so that you don't have to calculate interest properly. That's fine with me. So they'll say interest will accrue effective the date that your account went delinquent, or the date that the first assessment was due, if you don't pay within these 30 days. Great. If you have an affidavit in the official records of the association as to how and when this was mailed out, which we generally prepare for our clients to use going forward, just like the notice of late assessment form, that affidavit creates a rebuttable presumption that the notice was actually mailed out. Sorry, my throat was getting a little dry. So that basically says, yep, this confirms the notice was mailed. No argument. There's really no reasonable argument that the owner could make saying you didn't mail it out. And it's deemed received upon mailing, meaning that you don't have an obligation to ensure the owner received it. You have an obligation to send it out.
Alan, have a sip of water. I want to go over the evaluation really quick, since we're at the end of the advertised time and some folks need to get out of here, even though there's a few pages.
Oh, I thought we had 3 hours today. I apologize.
No worries there. Folks, for those of you who do need to go, Alan, we still have a few more slides to go, but if you need to get out of here, the last thing in the chat right now is the link for the evaluation. So just follow the directions on that page there, fill out the evaluation, scroll to the bottom, hit submit. After you hit submit, you get a confirmation screen, which forms a certificate. You'll see a yellowish rectangular box there. At the bottom is a link to print that. And beneath that is another link to download and save the slides. I'll go over that once again when Alan is completed with the rest of the presentation. But if you do need to head out now, you can get your certificates and you will get your CAM credit if you must go. Alan, back to you.
All right. Well, I'm going to be super quick now that I know that technically we're already over time, because I do want to get to the Q&A. And again, I apologize to anyone that's on that does need to head out. You're more than welcome to do so. We've covered enough that I'm comfortable making sure that if you complete what Jeff just mentioned, you do get your certificate. You've done enough here. But let's go ahead and finish up. I am going to breeze through this now that I know that we didn't skip anything. We're allowed to technically skip 2 of these sections. So we might be done when it gets to this, but I'll mention anything I think is important. The next 2 notices you're going to send out are a notice of intent to file a claim of lien, which basically says, here's what's due. It includes the attorney's fees and costs have now been incurred. And it basically says, if you don't pay within 45 days, we're going to record a claim of lien against your property. You'll then record the claim of lien and send a final notice, which is called a notice of intent to file a foreclosure action. That's going to say, hey, you got another 45 days, again, sent via certified mail return receipt requested with a copy to the property, and also going to say, here's what you owe. If you don't pay within 45 days, we're filing a foreclosure lawsuit against you. Then you move forward with your lawsuit. It's just like any other lawsuit, which, pardon me, if you have counsel and you've dealt with lawsuits before, hopefully you understand how that works. If you don't, there are innumerous resources. I don't even know if I just invented a word, but I hope I didn't. If I did, great. I hope it catches on. But there are many, many resources available that can guide you through what a lawsuit might look like. The difference between the foreclosure lawsuit and any other one is that in addition to your final judgment, that final judgment is going to say not only that the person owes you this money, but if they don't pay that money by a specific date that's going to be put into the form of the final judgment, then a foreclosure sale will actually occur, at which point that property gets sold at an auction. It's either going to be online like eBay and for the property, or it's going to be in person at the courthouse. So we're going to skip some of this mortgagee liability stuff because I know we do have some Additional stuff that we'd like to get through, namely the Q&A. Practice tips: your attorney can move a lender's case forward if it just sits and stagnates. So if you see that you're monitoring a mortgage foreclosure case and there's no action on it for the last 6 months, contact your attorney. If they're monitoring it, hopefully they're contacting you to let you know, hey, nothing's going on here. If you want us to move this forward, we're happy to do it. These are just some ways that you can do that. Let's see, we talked about how the association's manager and other people can't buy property instead of having an association foreclosure sale or at the association foreclosure sale. We talked about rent demands. We did not talk about receivership. That's essentially where the association doesn't have enough directors to properly operate, or it's just not operating. Any member can request the appointment of a receiver to basically run the association until there are actual directors appointed who are going to do the job. That is generally going to be an attorney who's going to get paid a lot of money to run that community. So you want to avoid that receivership if at all possible. Okay, insurance, have it, maintain it. We talk about some issues that might arise with damage to the common elements, damage between units. That's all stuff you're going to want to contact your attorney for. You might want fidelity bonding of everyone who controls or disperses association funds. That might include the manager, which might be included in the management contract. Let's see. The unit owners do have an obligation to ensure the unit itself and its contents or declaration is generally going to be what dictates what is considered a common element versus part of the unit and who's required to insure what. The FHA, we're going to skip, and the ADA, we're going to skip. We do have a service animal class that is recorded and available on our website. I recommend going to that if the FHA and ADA is of interest to you. Bottom line, if someone says they have a disability, get your attorney involved immediately. That'll kind of forego the need to discuss some of this stuff. Because the bottom line is, if you don't have a policy that's been created with a process, an interactive process that's created by your attorney, you're probably going to screw up these emotional support and assistance animal questions, as well as some others that might arise in the context of the Americans with Disabilities Act and Fair Housing Act. Recall is basically, well, we don't care that anyone did anything right or wrong, but we want them off the board and we want to replace them with these people. If you get a recall petition, you'll want to get it to your attorney right away with all of the documentation. This is, you don't have a lot of time. The next slide says you have 5 business days after you receive the recall petition to review everything that's in there and see if it can be invalidated. If the answer is it can't be invalidated, chances are whatever directors were named in that recall petition are off and the new ones come on. If you're not willing to do that, then the owner who pursued the recall can actually file a lawsuit to try and get that taken care of and get that individual off the board. Those types of lawsuits or recall petitions won't be considered within 60 days of an election because it makes no sense to sit there and fight through a 6-month, 12-month lawsuit when during that period, new directors are going to be elected anyway. And then we talk about termination. It's essentially where the condominium ceases to exist and basically turns in most of the time turns into an apartment complex. 5% of the voting interests can block efforts to terminate the condominium. If it's successful, everyone gets paid out what is allegedly the fair market value pursuant to a plan of termination, the fair market value of their individual unit or units. The division needs to approve this. Generally, a court's going to approve it as well. And in the event of a total destruction, which is where this can be more useful, any unit owner can petition a court for judicial termination of the condominium itself, because frankly, it's impractical to try and rebuild the whole thing if insurance proceeds aren't going to cover the real cost of doing that. And that's part of why I believe the Surfside condo was terminated and is now being rebuilt as a new one. But we've made it to the end. I apologize for going over. I wish I had recognized that we're doing condo only and not joint, which is 3 hours long. but here we are. So Jeff, let's blitz through some of this Q&A so that the
Yeah.
people that ask their questions that are still around might get answers.
I've got them. I turned off the Q&A so it doesn't get out of hand and we don't have to ignore any of them. So I have them on the
Perfect.
side here. I'll read them out to you. But I must say, between recall and termination, you got me wanting to watch an Arnold Schwarzenegger movie. So anyway, the first question is an amendment to a declaration to lengthen the minimum rental term a substantive or procedural provision?
So what we're talking about when it comes to substantive or procedural is changes to the statutes. So when we're talking about amendments to a declaration, that Kaufman language becomes irrelevant if that's the basis for the question. What we're talking about is amendments to the statutes, not the declaration. Now, when we're talking about, to answer your question anyway, my opinion would be that's a substantive change, because we're talking about the right to rent your property, the right to use your real property in the way that you want it. So in my opinion, that would be substantive rather than procedural.
Okay, and this might be easier. Let me do this as well so you can see what I'm seeing. Why doesn't the authority to suspend use rights have to, one, be in the governing documents, or two, allowed because there is a pre-7110 Kaufman language? I agree with you on fines, but not on uses rights.
Well, that's what the Florida case law says. That's why I don't have a better answer. And it's really not the use rights that is the subject here. It's the suspension of voting rights, which are a substantive right. The right to vote is a substantive right. So we get back to the Kaufman analysis that I just mentioned. When it comes to why is one allowed versus the other, why would one apply differently than the other when you're comparing use of your community to being fined? I think that the procedure for a fine, someone telling you now owe some money, is very different from I bought into a community that had a pool and now I can no longer use the pool. I think that right to use the pool is more of a substantive right versus it's not being able to fine versus not able to fine. I don't have a good answer for it, but I'm trying to explain my thought process. But the reality is sometimes that's just the way it is.
Just the law. Yeah, this sounds more like an opinion question. Our next question on this edition of Stump the Attorney is if the maximum fine is $1,000, how do you suspend use rights if the amount due has to exceed $1,000?
Well, you wouldn't necessarily be suspending use rights for the fines. It would be suspending for the violation itself.
Okay. Is a rule that only allows unit owners to speak on designated agenda items during new business a reasonable rule? Doesn't such a rule have to be reasonable? So I guess this, again, it's what the law says versus what you think.
So the answer is probably not, because if you're saying only agenda items, generally speaking, unless your new business is broken down by every item of business that's going to be addressed, you got to give the members the right to speak on all agenda items. So if you're saying you're only going to allow them to speak during new business, then hopefully that new business section is where you're talking about all of the issues that the board actually intends to address. Technically, I would argue they need to be authorized to speak on old business as well. The other thing that I may or may not have mentioned, because I go through this and frankly, I don't always think about what I'm saying, whether I said it last time or not. I think about what I'm saying, but not whether it's the same as the last time I taught this class. It is entirely reasonable to say you need to sign in beforehand and you will only be allowed to speak on any items if you have done so. But when it comes to the distinction between new business and anything else, it comes down to, is that when all of the actual business is being conducted? If the answer is no, there's probably other times that you'll need to give the members the right to speak.
Got you. Okay, I've stopped the share so that people can actually see your face when you're answering questions here.
Oh, thank you. I'm sorry. I thought closing out the entire window would do the trick. I guess I was wrong.
Let's see here. Since unit owners who have had their voting rights reduces the number on which a quorum is based, isn't that helpful in lowering the number of unit owners that constitutes a quorum?
It's not, because you're now taking the same percentage, but of a lower overall figure. So if you went from having 100 unit owners to 50, yes, you might be able to reach a quorum easier. But if you're talking about a vote of the overall membership versus a majority of a quorum, which is frankly what's required for most things. But let's say you're doing an amendment that requires 2/3 of the entire membership. Well, now you've lost 3 potential votes. So as to the question, yeah, it may be helpful to have less people voting overall. It's not always going to be a hindrance.
Right.
But it depending on what you're trying to accomplish and the actual type of vote that's required, presuming it's a member vote, not a board vote, you may be hurting yourself more than you're helping.
Right. Okay, we just have 3 left here. This one comes up quite a bit. And as most of you know, I'm not an attorney, but this one rarely ever makes sense to me. You know, because the way I feel is when you have a quorum of board members meeting to discuss business, and again, I'm not an attorney, but I always feel like how can a board not get together? You want to get the facts together, do your research. You want to be able to smartly present to your owners what it is you are presenting. And how do you do that if you don't get together ahead of time to discuss the dang thing? So the question is, why do you think that a quorum of board members can meet outside of a properly noticed board meeting as long as a vote is not taken? It seems to me that conducting business includes a discussion where votes are not taken. So again, that's that. What side of the fence do you sit on? I'm like, if I'm on the board, how the hell am I supposed to discuss intelligently with my other board members before presenting it to the masses? It's just, this makes no sense to me.
Well, I mean, to some extent, I understand the question, and I don't necessarily disagree conceptually. The problem is exactly the one that you're explaining, that it's impractical at best to say the board is not allowed to discuss any of this stuff except at a board meeting. They're not voting. They're just trying to gather information and discuss. Yes, the discussion needs to be reheld, which I said during the presentation. If you're going to discuss this stuff, it needs to be reheld. But from my perspective, if you can email back and forth as much as you want and discuss matters, and that's not a board meeting, it would be absolutely absurd, in my opinion, to argue that you can't have that same discussion in person without voting on anything, without deciding it. So I totally understand where the asker, where the petitioner, I don't know what to call the person, where this person is coming from.
A student.
Because it is difficult to reconcile the fact that you're not allowed to vote outside of a board meeting. But my question is, if you are not making a decision, are you conducting business, or are you preparing to conduct business? And that's where I draw the line personally. I don't think, frankly, that the majority of attorneys in our firm would agree with what I said today. But my opinion is there's got to be a line drawn as to what is and is not conducting business.
You know, Alan, the part that doesn't make sense.
You're not conducting business, in my opinion.
Yeah.
And again, this is just my personal opinion. You know, it's that disclaimer at the beginning of every radio show that the presenter's opinions do not represent the opinions of the firm. I don't know that opinion represents the opinion of my senior partners or any other attorney in the firm. It just makes no sense to me to say you can email back and forth as much as you want.
Yeah.
You can meet separately and discuss this with one other director if you've got a 5-member board. But as soon as that third person steps into the room, shut your mouth, walk away, and schedule a board meeting. It just doesn't make sense to me.
And now I have a Pedro Martinez curveball for you. All right.
I can't wait.
We talk about when the proper way to take minutes. All right. And I think you know where I'm going with this. The proper way to take minutes is don't put everything in there verbatim. So you're going to repeat that discussion that is or isn't business when a board is doing research, but then it's not really supposed to be in the minutes. And that's why none of this makes sense to me, because the definition of minutes, and correct me if I'm wrong, is that it's just the yes or you describe what the motion is and just report yes or no. Did it pass or did it not pass? All you're really supposed to say is discussion ensued, and then the vote was taken. So how it, again, that's why none of this makes
Well,
sense
Jeff,
to me
look at the
anyway.
word. Look at the word minutes. It's not seconds.
It's not hours.
Milliseconds. It's minute.
Yeah,
It's literally, it's not, it's minute. It's not the minutia. It's
yeah,
literally, here's what happened.
right.
I mean, I know people that will go to the extent of saying these are the individuals who had something to say, and whether they were for or against the motion that's being made. But I don't really see that as necessary.
Yeah, yeah,
It's literally, here was the motion, here's who made it, who seconded it, here's how everyone voted.
right.
Discussion is for the purpose of making the decision. If you want to put some of that in writing, send a letter to the association and shove it in the official records.
Yeah.
But it doesn't need to go in the meeting minutes, which are literally just a record of what was decided.
In essence, in other words, the business. So that's why, and
Right.
that's what doesn't make sense to me. That's the actual business of what the board is doing. Yet opinions vary on the research aspect. Okay, let's move on.
Well, and I'll go one further, Jeff. Okay.
Yeah.
You know Robert K. In his
I do.
opinion, if it's not in writing, it probably never happened.
Probably never happened. Yeah.
So if those minutes don't exist, but there was a board meeting, what record do you have that vote was ever taken, that it was ever discussed in the first place?
Yeah. Yeah.
And by the way, how many people show up at your board meetings to attend that discussion and participate in it? 5, 6?
Typically the same folks every month, unless they
Right.
have a project that they tend to be interested in.
Right. So, I mean, that is not a legal basis to say we didn't have to meet. And I'm not suggesting that you didn't have to have an official meeting to make that decision. But
Yeah.
in fact, I kind of am, because I mentioned that written consent form earlier. You could do almost all your business by written consent unless it requires a member vote.
Yeah.
It wouldn't even be feasible if you weren't allowed to discuss these issues outside of a board meeting. How do you get that unanimous decision?
Yeah.
So there's got to be a mechanism that allows for that type of discussion. It just makes no sense to say anytime you're talking about association stuff, you got to cut it off right away once that third person steps in the room.
Yeah. Hey, good stuff. Good stuff. All right, there's two more.
All
What
right.
is the reason? What is the reason? I'm going to see if I can interpret this question properly. It's kind of broken up. What is the reason if the association, what is the reason for the association purchasing for the association? I don't know. I guess we're going to have to skip that one.
Okay.
Let me try one. What is the reason if the association is purchasing for the association? Does that make any sense to you?
What is the reason if
Let's skip. Yeah. Right. If the person who wrote that question is still here, clarify it in the evaluation. We'll try to get an answer for you. Last one is, can someone give me some advice on where I can go to study community association law? I have not had any luck with this question.
Where you can go is
Right
classes
here.
like this that our firm teaches, and don't limit it to me, by the way. Get different opinions from different attorneys within the firm. There are plenty of other firms that provide education. It's never going to be as good as ours, but there are plenty.
Let me cut you off. Maybe this person is looking to become somebody like yourself, a community association attorney. Do you have any recommendations on? I think this is the obvious part. Take a lot of these classes. What if this person is actually asking and wants to become a community association attorney?
I really hope they'll email me, because I'm looking for an associate. And frankly, so are 2 of our other offices. So if this is an attorney that is seeking to be a member of the firm, or a member of this industry, or it's someone in law school, honestly, my best answer is going to be get in touch with me. I mentor people all the time in this industry, and I'd be happy to go to that extent for anyone that's actually going to show an interest. The other resource that I'll suggest, although it's outdated and is being replaced with a version that I wrote for, is if you're interested in condo in particular, we call it the Green Book. Let me see. I might have, I'll be right back.
I would hum the theme of Jeopardy.
In my office. This is it. Florida Condominium and Community Association Law. There's a new version that should be coming out in the next 6 months or so that is only the condo portion. I wrote the covenant enforcement defense portion of that. And then the HOA one will probably come out in the next year or two. And I wrote 7 chapters of that one as well and served on the steering committee. So very proud of that one. It's going to be a really good resource. There are 2 or 3 other books that I had and never really used because I had this book. So I don't remember what they were called, but I know if you go on Amazon, there are 2 or 3 other decent condo books and HOA books, but I think actually the condominium concept might be the name of one of them. But honestly, if this is an attorney or someone that's just looking to get into the industry, send me an email directly. You've got my email address in the materials today. And I'm always happy to mentor someone that's interested in getting involved, whether that's on the management side, on the association attorney side, or just someone who wants to know more about the industry.
All right. Sounds great. Thanks for that advice. I'm sure the person appreciates that. Those were
Oh,
all
yeah,
of our
absolutely.
questions. I know you got to get running. For those of you who might have been looking forward to listening to Alan or watching Alan tonight on Ask the Experts, due to circumstances beyond our control, that show tonight will not be live. The host informed us. Alan will be live this Thursday, assuming that everything is back to normal with the organization that puts on the television show. So look for that email. But tonight at 5 o'clock Eastern will not be live. So Alan, you have a little more free time.
What's that like? I don't understand.
I don't know. So I know you got to run. Great job. Thanks again. You can take off anytime you need. I'm going to hang on for a couple more minutes and I'll go over the evaluation process one more time.
All right. Thank you, Jeff. As always, great job yourself. And thank you to everyone, especially those of you who are still here after 3 hours. Really appreciate it and hope you all enjoyed the show. I'll look forward to hearing from everyone soon.